Advocate Mutlamunyane. Advocate Batoy, we thought that before you begin counsel, counsel from the NPA should, as and when it is necessary, she can sit next to you actually. Is it possible to have that chair being brought closer to her at the corner? If necessary, you can whisper to Ndate Nkabinde. But feel free to sit there. And when it is necessary, Madam, you can go back to the junior counsel, but take that as your seat from now to make it easier for Advocate Batoy to page through her documents. And when you need to go back to the other side, feel free to do so.
Thank you, Chairperson.
You may proceed, Ndate Mutlamunyane.
Chair.
Thank you, Madam Chair. Yeah, I was getting to it.
Okay, sorry.
When we adjourned, Madam Ramachakha wanted to ask a few questions for clarification to Advocate Batoy.
Good morning, Chair. I'm still of the intention to ask questions, and I will proceed to do so. Advocate Batoy, can you just advise as to why we were only getting annexures to Dr. Braff's report yesterday? Or is it annexures to Dr. Braff or whoever you think that supplementary documentation that we received?
Yes, thank you. Those are not annexes to Dr. Broughton's affidavit.
Yes.
Those are annexes to what has been referred to as the de Kock report,
Yes. Yeah.
which is part of my affidavit.
Yeah, thank you for the correction. Why were we only getting those annexures yesterday?
The reason for that is that because of the volume of it, it was the de Kock report. If one reads the de Kock report, it's clear that they are annexures to the report. And it's also clear that those annexures are not attached to my affidavit. The reason why we didn't do it is because I think in my affidavit we refer to, I hope we do, or the de Kock report refers to the annexures, but I'm not sure whether in my affidavit we actually refer to where in the bundles they can be found. My understanding is if you look at my supplementary affidavit, some of the, and I'm speaking from memory because I'm not looking at it now, but some of the documents are documents that are in the bundles, and there's a reference to it. And some of them, thank you, and some of them, if you look at, in my affidavit, paragraph 13, as I explained yesterday, the first three annexures to Advocate de Kock's affidavit, well, not his affidavit, the panel report and opinion are in the bundles, the first three. And the remaining four are not contained in the bundles. It was only because of the voluminous nature that we did not attach it. And I would suppose because of the serious time constraints that we had in terms of trying to put my affidavit together. And that's the reason.
Yeah, I'm asking this because it is my understanding that when you read a document that refers to annexures, that document will only be complete when you also read the annexures.
That is correct.
So the proper thing to have been done would have been to avail those annexures simultaneously with the report.
Accepted, Chairperson.
Thank you. Now, on the balance of the your affidavit, are there still any outstanding annexures to the documents that support your affidavit? Or as far as you are aware, all documents have been availed?
We must check that because some of the documents referred to in my affidavit, for example, Dr. Broughton's report and the annexures thereto, those annexures were certainly not attached to my affidavit because of the voluminous nature of it. But my understanding is that those have been uploaded and we can refer to them. What I propose through you, Chair, is that we do is go through my affidavit carefully and make sure that every document that is referred to either has an annexure attached to it or there's a clear reference to where it can be found in the bundles, so that the panel can easily access the documents.
Yes, yeah, that is the exercise that ought to have been undertaken earlier, but I hope in my questioning it will not become necessary for other documents that are outside the record that we have that would have to be brought in. Now, when do you say you formed an opinion that Advocate Chauke's conduct requires or necessitates the establishment of an inquiry?
As I mentioned, I had been considering this matter for a while, and I had been receiving opinions over a period of time. In fact, it spanned years from the first Nalane report opinion. I finally would have decided to refer it at the point I had considered the evidence in the Boyson matter and the evidence in the in the Ndluli matter that had been placed before me. So after that, I made my final decision to refer it, and then I wrote to the minister.
Yeah, can you just give us an idea, when did you form the opinion, or when did you come to a conclusion that this matter or this conduct necessitates a recommendation for an inquiry to be held?
When I had looked at all the
Yes,
evidence.
the timeline, was it around February 2024, 2021, and so forth? That's what I'd like
I think
to.
it would have been finally on the Boyson matter. I had made a decision after. Well, I'll look for the timelines, but just in terms of when, it would have been. I was clear after I looked at Dr. Broughton's report. With regard to the Ndluli matter, I made the final decision after I looked at the evidence that was attached to the Hali and Wenzel. And we can look at opinion, and we can look at those to get dates. If you'd like me to do that now.
Yeah, it'll help. I don't want us to be going back again and forth. At least let's travel this path and, moving forward, and without having to time and again go back and check.
Certainly, I would appreciate that as well. So if we can we'll try to get the documents to make sure we have the timeline. Dr. Broughton's report is the date of that. If we can just look at the date of that, that will be the first thing. So the second report, and understand I'm giving an estimate of the timeline.
I understand well.
The second report of Dr. Broughton with all the annexures is dated the 21st of April 2023. I would have taken time to consider all of this, and it would have been, the decision would have been made sometime after this. When I did, before I got the opinion of, and I'm trying to get the timeline, maybe we'll get the opinion, if we can get the opinion of Advocate Hali and Wenzel, that will give me a sort of window period when I was considering these matters. That opinion is dated I do know that I certainly looked very carefully at all the evidence in the Broughton report. This document is dated the 10th of July. So it would have been sometime between the 21st of April and the 10th of July that I would have decided that I had sufficient evidence with regard to the Boyson matter to refer the matter.
And the Mdluli matter?
Yes, in a moment. Just want to make sure I make a note of these dates, so when I'm asked later, I'm not trying to understand what those dates were again. 21 August until 10 July. Okay, and the Mdluli matter, it would have been sometime after the 8th of, this is 8th of July? Sometime after the 10th of July, and the date on which I sent the referral to the minister, which is an attachment. I think it's in my bundle. I think it's SB10. I think it's SB10. SB10 is dated the 18th of August 2023. It's page 275, SB10, and the date of that is 18 August 2023.
Is 18 August 2023 the date on which you took the decision in respect of the Mdluli matter?
No, it's not. I didn't give a date. I said there's a window period. It will be after the 16th of July. No, it's not 16th, 10th of July. 10th of July 2023, when I got the Hali and Wenzel report. Between that date and the 18th of August 2023, when I forwarded the recommendation to the minister.
I beg your pardon. I think we're going to spend some time on three documents to get clarity on issues. And those will be the SB5, which is in pages 231 to 235. And then SB 5A, which is in pages 236 to 237, and then SB 6, which is in pages 240 to 260. And LO1, which is in pages 30 to 119. Yes, I think that will be the main documents that I will seek clarity in respect of. But I will then start off with the SB 5. Ne? SB 5 makes reference to a request for further information. You say it's headed request for further information relating to decisions made by you as the SDPP. Now, a request for further information supposes that there was information that had been received earlier, and this is a follow-up to request for further information. Now, what I would like to get from you is, when was the other information received by yourself or obtained by yourself? It may have been something that is lying in your records, or it may have been something that you actually sought for from someone.
So must I go through each one of those matters?
No. Yes, I'm asking as to, if you ask for further information, it means you have some other information that you could have possessed, either by virtue of being in the office, or you could have obtained from someone else. The first question is, the information that you already had, where did you get it from?
Okay, so I'll deal with each one of the matters. I did refer to it yesterday, but I'll deal with it again, each one. So the Boyson matter, we'll start off with that one.
Yes.
So with regard to the Boyson matter, there was a lot of information that I had. I had information, well, the Zondo Commission was in progress, and there was a lot of evidence that was tendered there. There were court decisions relating to the Gauteng judgment. And yeah, so there was all of that information that I had, which led me to, especially given the Gauteng judgment, to the point where, as the national director, I believed I couldn't bury my head in the sand. I needed to look into this, because there was clearly, having considered having all of this information, something that I needed to inquire into. So that's the Boyson matter.
So with regards to the Boyson matter, there was information in the records of the NPA, there was information out in the public in the form of the court judgments and court matters, and as well as the Zondo Commission. Right, thank you. And then with regard to the Mdluli charges?
And with regard to the Mdluli charges, they had been, at the time, I recall, there was let me just say, talk in the NPA that these charges were that Richard Mbluli was being protected and he was not prosecuted in these matters. In fact, I do recall that I spoke to Zeiss van Zyl himself. We'd had one of the, geez, I can't remember the date or even the year, but I'm thinking it was reasonably early in my term. It certainly would have been before this letter, I imagine. But it's part of the information. You know, there was part of me getting the information, but I can't recall when I got this. But I know it was early in my term. I spoke to Zeiss van Zyl, and he told me he's the prosecutor.
SC?
That is correct. Advocate Zeiss van Zyl, he was a deputy prosecutor, deputy DPP in the Johannesburg office at the time, and was the lead prosecutor in the Richard Mbluli murder matter. I'm not sure what his role was in the others, but he might have been the lead prosecutor in all of the dockets. I did have a conversation with him, and he told me about the very strong case that they had in this Richard Mbluli murder case. You'll note from my letter, I say there, I have perused the NPS representation file to this matter. From a reading of the documentation contained in the file, I understand that Mbluli was arrested at the beginning of 2011, whereafter a decision was made to indict him and 3 others in the High Court for several charges, including murder, attempted murder, intimidation, kidnapping. The trial would have commenced on April 2012, but following a representation, you decided to withdraw charges and a formal inquest was held. I then refer...
Advocate, but I've read.
Okay, so that was the information that I also had.
Yeah, but what I was asking is, where do you get the that information? You have said there was talk in the NPA about the Mbluli case, and also that you spoke to Advocate van Zyl, who informed you that there was a strong case.
There was also,
and who else or what else? Just give me the source, and you don't have to really read this. We have read this again.
I'm reading it to refresh my memory so that I answer properly. So this is a long time ago. I am trying to refresh my memory, but also, so I had the NPS representation file as per paragraph 2.1. There were also the judgments in the Mbluli matter, the freedom under law case that I referred to in paragraph 2.2. From my recollection, that was the information on the Mbluli matter, but as I say, it may not be exhaustive.
And the information relating to the Karima Brown complaint?
That was a complaint from Ms. Brown herself, and I see that annexure was attached to my letter. I'm not sure if it's part of this bundle, but if not, is it? I think if we could check, if it is, let me check the index and see if it's in there. Oh yeah, it's 5C, SP 5C. So that was what triggered
the complaint that your office received.
That's
from
correct.
Ms. Karima
That's correct.
Brown. Okay,
that was
the basis.
the information. Paragraph 4, as I'd indicated.
So just before you, now when you said you are asking for further information, is there any information that you had received other than the complaint?
Not that I can recall. I think it may have been in the public space. There may have been some media reports about it, if I recall, but I'm not sure.
You're not sure?
I'm not sure. I think it was in the public space.
Okay. But Advocate Chauke had not as yet furnished any information to you
Not that I'm
with
aware
regard
of.
to the Karim.
I can't recall, but I don't think so.
You don't think so?
I can't recall.
You can't recall. Thank you. And then
So I I do feel like I'm being cross-examined, but I do. I can't recall.
Maybe
Sorry.
it does help, to express your view
Thank
that
you.
you feel like you are being cross-examined.
Yes.
And I think the other day the chairperson touched on that
Hmm.
to explain, and it's an explanation out of courtesy, because this inquiry is an inquiry of lawyers about lawyers. And I think all of us understand the term inquiry, and all of us understand the nature of the inquiry that we are now conducting.
And I think we do understand
Please,
cross-examination as
ma'am,
well.
please.
My apologies.
When I speak, please listen
Certainly.
and respond at your time.
Certainly.
So we understand, with an inquiry of this nature, part of what you do as the panel, you've got to make sure that you get all information, so that when the time comes for you to write a report, you don't wish to call people that testified and to ask them for more information. And in this particular inquiry, you are the key witness. Any other witnesses that come after you are not really key. They may be important, but they are not key witnesses, because this inquiry has come into being because of your opinion. And your opinion was also based on other opinions that you obtained. But at the end of the day, it's about your opinion. And any other witnesses that may come here after you, they will not be able, or they may not be able to answer adequately about issues, especially with regard to motivation for the inquiry to be held, and many other things. If they come here and corroborate, that's fine, that becomes a bonus. But at the end of the day, this matter should be traversed properly and adequately in respect of every witness, including yourself, and while mindful of the fact that you are the key witness, right? So we are inquiring. It is unlike in a court of law. In a criminal case, where there will be cross-examination. And I think as a seasoned lawyer, you understand, or generally, with the rules of cross-examination, that you ask leading questions. You're not asking for information. You are giving information when you cross-examine, and you expect responses. And that is not what is happening here. We are trying to get information. And I will proceed on that understanding. And I just want to make you understand that the panel is not confused about what is cross-examination and what is asking questions for clarity, what is asking questions in an inquisitorial environment, and what is leading evidence in chief. There's no confusion about the concepts. Now I will proceed.
May I comment on that?
Yes, you may.
Thank you. That's very helpful. I think it's important that we are all on the same page, because the chairperson did indicate to me in chambers as well that there's not going to be cross-examination. So I'm glad that we are all, there are differing views about it. I certainly have my own view about this, but I've got to be part of this process. I'm here to help the inquiry, and I will continue to answer the questions to the best of my ability. I do want to, in respect of me being the key witness, of course, I agree it's an important witness. My views on things that happened prior to me taking office, of course, important. But all of that other evidence that is being presented outside of my views on this is the hard evidence in this matter, which in my view is, I'm not saying my view is not important, it's critical, because as you say correctly, I referred the matter having a reasonable belief that this matter needed to be inquired into. And this is the inquiry. And my evidence is, in fact, in many instances, it's hearsay, and there will be other evidence by witnesses, documents, etc., that will speak for itself. So I wanted to make that point. Thank you.
Might I take this opportunity to clarify your statement as you answer Me Ramakhacha, that I made it clear in chambers that you will not be cross-examined. Did I understand you to say that?
That is correct, Chairperson.
It is important to put context to that question, to that answer, rather, and place that correctly on record, that it is not correct that I said that you will not be cross-examined. You know why I'm saying that? That following the parties' submissions or memoranda requesting that this inquiry should begin in February 2026, we considered it appropriate to call you as the head of the NPA and caution that it cannot be that your team, including the evidence leaders, or the view that we should begin this inquiry even 4 months later than the date that has been allocated to this inquiry, correct?
That is correct. I, in fact, agreed with you.
You indeed agreed. It was in that spirit that we considered appropriate to call you as the head of the NPA, so that you could sound a caution to your team to do things right. Because at the end of the day, the buck stops with you, correct?
That is correct, as the head of the NPA.
And we made it clear to you that this inquiry will not begin in February 2026, as was requested by the parties, precisely because we believed that when the complaint or the referral was made to the president, the NPA was or ought to have been ready to kickstart with the inquiry. Correct?
That was indeed your view, Chairperson.
And we formed the view that although the NPA is dragging its feet in providing information, we will begin to hear or to proceed with this matter on the 17th of November. Is that correct?
Chairperson, you did mention that. And I think in the context of our conversation, I explained to you that the NPA was really trying hard, given the volume of documents, to get things together.
And that meeting took place a day after I had called you telephonically, requesting you to attend the meeting. And during our discussion, you mentioned that you wouldn't want to be cross-examined.
Chairperson, that was in the course of our meeting when we met at your office. I said to you that I wasn't even sure that I was going to be testifying in this matter. And you expressed the view that it would be important that I do testify. And I agreed that I do. And I said to her, as I recall saying something along the lines that, yeah, you know, cross-examination is something that you don't look forward to. I certainly wouldn't look forward to it. And in that context, I agree. We talked about cross-examination, and the judge then made certain comments.
I'm referring to my telephonic discussion with you when I called to request you to attend a meeting at the chambers. Do you recall?
I do recall the conversation, Chairperson.
And during that discussion, you expressed the view that you wouldn't be keen to be cross-examined. And I said to you, we need not talk about that. We will have a discussion the following day.
Chairperson, I can't recall, but I don't doubt it. I have absolutely, I agree that if that's what you say, that's what happened. I know we talked about it the next day.
And more particularly, you expressed the view that you wouldn't want to be cross-examined by Advocate Andrew, and I cautioned you that let us not discuss this matter on the phone. Let us have a meeting with you.
You did indeed caution me and said we should not discuss it on the phone and we should have a meeting the next day.
Now, at this meeting, in respect of which we wanted to discuss with you as the head of the NPA about the starting date of the inquiry, we clearly said to you that you will be the first witness to testify because you are the complainant who should set the tone of the inquiry. Is my recollection correct?
You did indeed say that, Chairperson.
And at what stage did I express a view that you would not be cross-examined?
During that meeting, Chairperson, my recollection is that I did mention the issue of cross-examination at that point, and that you mentioned that it will be questioning, but no cross-examination. That's my recollection, because it is an inquiry.
You see, Counsel, it is very important not to misrepresent facts to anyone, especially when you impute information to any presiding officer.
I agree with that, Chairperson.
It will be totally unacceptable for you to impute wrong information about me or about any of my colleagues sitting as panel members. I'm going to park it there and close by saying, in any event, it will be totally uncalled for to even discuss issues relating to whether you will be cross-examined or not when there is a litigant against whom you have made allegations. Advocate Chauke is represented, and there is no doubt that you will be cross-examined. And I'm sure you understand that.
I accept that I will be. I have no doubt about that either.
I'll leave it there and ask my sister to take it up if she wants to do so.
Just to add, and I'm going to try and quote you the way you put it. When you raised the issue of cross-examination, I remember saying, "Are you scared of cross-examination?" And you said, "No, I'm not scared to be cross-examined because I attend the Justice Portfolio Committee where I get cross-examined all the time. Do you still remember that?
I do.
So you accept that there was never a time when you were promised that you will never be cross-examined, because that never featured in our meeting with you.
Your comments are noted, Chairperson.
Pardon?
I say I note the comments.
I beg your
I
pardon?
note the comments.
You know the comment.
I do. Thank you.
Might I caution counsel that all of us are lawyers here. You are a lawyer. The litigant is a lawyer. Advocate Chauke is a lawyer. The team, we are all lawyers. We
That's correct,
understand
Chairperson.
basic principles of conducting disciplinary inquiries. And it is important that we take one another into each other's confidence, because we are here searching for the truth. And it will be totally improper for anyone's name to be dragged into this record, basically on any proposition or suggestion that we have misconducted ourselves. Because if you put a statement to the effect that I told you something that is incorrect, it's putting me in a very bad light. It is for that reason that I placed this context on record, so that anyone who reads this record at a later stage understands why a discussion was held and why you are incorrect to suggest that I told you that you will not be cross-examined.
Chairperson, if I may, I certainly did not intend to suggest that the chairperson had acted improperly in any way at all. It was my understanding, and so I really apologize if that's the way it came across, but it was certainly not my intention to create that impression that there was anything improper that was said to me during that conversation at all.
The question is whether that was said or not.
It was my understanding, in fact, precisely in the context of what Madam Baloy Mera mentioned, that we did speak about cross-examination, and I did indeed say that. That was my understanding. It could have been a mistaken one, but that was my understanding.
Yes, thank you.
Thank you, Chair. Yeah, I had asked you about Ms. Karima Brown. You had indicated that you had received a complaint. Right?
That is correct.
And now let's proceed to the next matter, is the matter of Brian Hlongwa. Remember that the question that I'm still asking is about further information
I do.
requested.
So Brian
It's
Shlongwa matter.
about further information
Correct.
requested.
So the Brian,
So, it is not apparent from paragraph 4 as to where you have received the information from. I may be wrong, because when I read the third sentence, it says the DNDPP NPS has requested you to provide reasons for the delay.
sorry, I'm just trying to get back to the page.
In the matter, it's page 234, SB 5234.
Yes, I'm there.
The DNDPP NPS has requested you to provide reasons for the delay in the matter, and I've been placed in possession of same. So when you say that I have been placed in possession of same, what are you talking about? Is it about the request by the NPS, or is it about any other information that Advocate Chauke could have provided or had provided by then?
So I'm going to try to the best of my ability recall the events prior to that. I have testified here before that after I took office, General Labia mentioned this matter to me and expressed his concern that this matter had not, in fact, I can't recall whether it had been withdrawn or they were about to arrest Brian Shlongwa and they were stopped from arresting him. I can't remember the details, but his concern was that it was now about 7 years later and the matter had not been enrolled. As a result of that information, I discussed it with Advocate Chauke, and being the deputy in charge of the NPS, on the basis of this, and I'm trying to refresh my memory, what would likely have happened is Advocate Chauke would have sent a letter to Advocate Chauke and asked him for, well, sent a letter in response, and Advocate Chauke would have responded to that. That's what my note here says, and I'm giving him the opportunity to add anything further.
Yeah, you know the institution that we are talking about here, it's an institution that I believe is an institution of record. And it will help, it's to try and, I don't know, when I say remember, I can't say you can only remember to an extent possible within your capacity. But at the same time, where you are raising issues about conduct, it helps to get the records. Did you look at the records that pertain to the matter of State versus Brian Hlongwa? Or did you then get information, it would appear, unless you indicate otherwise, in passing, from General Libya and Advocate Chauke? And just to avoid giving you a compound question, I must break it into pieces. Firstly, let's talk about General Libya. Did General Libya present a formal documentation wherein wherein he was briefing you about the matter, bringing his concerns to your attention so that you can deal with the matter accordingly? Or how did he, and I'm still just confining you to General Libya, then we'll go to the next one.
With regard to General Libya, I cannot recall him sending a formal letter to me, but it was certainly not a conversation in passing. I had a meeting with him, my recollection, and it wouldn't have been a meeting about this particular matter. It would have been a meeting about other things. He's an important stakeholder. He was the head of the Hawks at the time, the DPCI. And of course, you have meetings with your partners in the system. And it was during one of these meetings that he expressed very serious concerns about this matter. That my recollection of this conversation was that it had been, I'm repeating what I said. So it had either been enrolled and withdrawn, I don't recall, or whether they were about to arrest Mr. Shlongwa when they were stopped from doing so by the DPP in Johannesburg. But he was very concerned that the matter had not been re-enrolled after that, because their understanding was that it will be. And I think there was what Advocate Chauke mentioned to me at a later stage, there was a possibility of racketeering charges. But that was not discussed in the meeting with General Libya. All he did was express concerns to me about the fact that a number of years had passed and the matter had not been re-enrolled.
you had a formal relationship with General Libya.
I'm not sure what you mean by a formal relationship.
Formal relationship as a stakeholder. You said he was a stakeholder, and I think it's common knowledge that he must have been a stakeholder there. He comes, he talks about something, serious matters, or a serious matter which is not getting attention and so forth. That comes through to me like it's a casual reporting. Like you say, there was no meeting about this. You had another meeting, you were at another meeting, then he tells you that there is this matter that is very serious, that is not receiving attention. And now, because it was not a meeting about this matter, we are likely not to get the minutes of that meeting or of that discussion. But at least, I'm sure, if he was serious and the matter was serious and it's about the concern, about the interest of the administration of justice, he could not have been that casual. I want to believe that he must have communicated with you in writing. He did not.
I'm not sure why the honorable panel member doesn't accept that it could have been something that was given to me during a conversation, because we're not just stakeholders, we are critical partners. We work together very closely on a range of matters and cases. And during one of my meetings, he mentioned this to me as a very serious concern that he had. I don't recall him sending anything to me in writing, but receiving that as a national director, I need to take it seriously. And I did. And from what I read here, because I'm trying to cast my mind back a number of years, Advocate Chauke or someone from NPS, I'm not sure if he was there at the time, because he joined the NPS in 2021, I think. So I'm not sure when this went to him. But there was a letter written to Advocate Chauke, and he was asked to provide reasons for the delay, because as I said, Advocate Chauke, General Libya was concerned that there were a number of years and the matter had not been enrolled. So in my view, that was the proper thing for me to do in the circumstances.
Yeah, well, I've noted the many. I don't remember. I can't recall. We spoke. It's fine. So the second line is saying the NDPP has requested you to provide reasons for the delay. Where can we find copy of this request that was made to Advocate Chauke about the matter?
We will check the NPS records.
Okay, so it will be provided.
Yes.
Of course. Yeah, the problem, I had hoped that today we would sail without the possibility of having to go back. We don't know what the document will be having. It may even then become necessary to go back. But then we'll see as it comes as to whether it's necessary or not. Let's go to the last matter.
Might I, if the document that is to be provided, shouldn't it be part of the list of the exhibits, Advocate Mutlamunyane? To the extent it may be necessary. Paragraph 4.1.
I see that, Madam Chair. It will be made part of the exhibits.
Advocate Batoi
If it is,
undertakes
yes.
that it will be provided. That request.
Which is supposedly in writing.
Supposedly in writing.
Indeed.
Please make a note of that, Madam Junior, and include it in the bundle of the index for the exhibits.
And it will be accordingly marked, Madam Chair, as an exhibit.
Yes. Yeah. Thank you. Proceed, colleague.
The last one is the matter of State versus Duduzane Zuma. Again, in respect of that matter, talking about the question of your source of information, where you requested him then to avail further information. You indicate that you have perused the representations. Please, it's SB5 234.
Yes, I'm there.
Yeah.
Thank you.
Oh, are you there? Okay, sorry. I'm not sorry about that because I did not mention the page number again. I've perused the representation file of office, but you are kindly requested to provide me with a further copy of your office file in which the record of the original decision not to prosecute is recorded, as well as copy of the related office files. Now here it is clear from what you are saying that you have perused some documents and now you are giving him an option, or you are inviting him to provide further information if he so wishes. Now this document that you had, the representation that you had perused, have they been availed to the inquiry?
Not that I'm aware of. I haven't
Yes.
even perused it since then. We certainly can make that available.
Yes, it will help to make them available, because in the beginning we can see that, there are the matters, right? I don't know whether there were even more than that, but we see that this letter of the 13th is referring to these 5 matters. And much as the inquiry now is proceeding in respect of the 2 matters, it does help to look at the matter holistically when we deal with the report, right? So that is another document that will be available.
It will be
The
more than a
representations.
document. My understanding
Yeah.
is that it's a file, because
Yes.
once there's a representation, there's a representation
That's
file
fine, yeah,
that
that's
is
fine.
sent. It's opened in the NPS.
Yeah.
So we'll certainly make available that file.
Okay.
And
No,
if I
yeah, that's fine.
if
That's
I may
okay.
confirm that with regard to that particular matter, Advocate Abrams overturned Advocate Chauke's decision and decided to prosecute in that matter.
Yeah, we'll come to talk about that. The focus of the questions that I've been asking now was just about
Sure.
the source and why you're asking for further information. Now, the issues about the matters will receive attention. I think we can then proceed to deal with now those matters in particular. And I think when we deal with them, I'll be maybe even cross-referring where necessary, right? Cross-referring between the SB5 and the SB6. Right. Now, let's look at the Boysen's matter. I've said SB6 pages 244 to 254. Yeah?
Sorry, what's the page numbers again?
SB6 244 to 254. Right? What I'd like to draw your attention to, or the inquiry's attention to, in respect of that matter, it's 244. at paragraph SB5, I'll start with your letter, that letter of the 13th. I think it should just be recorded that is the letter of the 13th day of May to Advocate Chauke. Then the SB6 is the reply to that letter. That reply of the 28th from Advocate Chauke to your group self.
That's correct.
All right. Now, in your letter of the 13th, at SB 5232, paragraph 1.2, the apparent accusation against Advocate Chauke is he's supporting a decision to prosecute. Do you see that?
Sorry, where is...
Paragraph 1.2.
Ah, yes, I see that.
1.2, and the conduct complained of there is supporting the decision to prosecute in this matter. I'll read that subparagraph 2 into the record. SB 5232, paragraph 1.2. As the lead prosecutor, explain why your reasons were for supporting the decision of the prosecutor in this matter. So in that one is the question of him supporting the prosecution.
That's correct.
Yes. And then a question that arises from that is, whose decision is he accused of supporting?
It's not a particular person, but it is the decision to prefer racketeering charges against General Boyson.
Yeah. The sentence says supporting. So when you support, you would be supporting something from someone, unless my understanding is wrong. It says, as the lead prosecutor, explain what your reasons were for supporting the decision to prosecute in this matter. Maybe let me hear from you. I think you can better interpret that. I may be misinterpreting what you're saying there. Supporting.
So what I'm saying is that there was a decision to prosecute General Boyson and on racketeering charges. And there would have been various decisions made at different stages in that process by different people. So you have a team of prosecutors who would be looking at the case. They may decide there's sufficient evidence and they make a decision then to refer the matter to the DPP in charge at the time, who was General Advocate Chauke. He then makes a decision to support that decision and then to support a recommendation, having satisfied himself, to the national director. So what I was saying here is just saying in one line to Advocate Chauke to explain his reasons for supporting this decision and being a part of that decision to prosecute General Boyson.
Let's then go to paragraph 1.3. Please also advise for your views on the regarding the legality of leading the prosecution to another purpose, as well as the team. Yeah, I beg your pardon. We should get the automated ones where you control from that side. Okay, this was not on record. I'll just read it again into record. Paragraph 1.3 reads, please also advise on your views on the legal position regarding the legality of you leading the prosecution in another province, as well as that of the rest of the team. Now, the first question that I will ask is, there are two paragraphs, subparagraph 2 and subparagraph 3. Do they relate to the same matter?
That is correct. They do.
Where in paragraph 2 he's referred to as the lead prosecutor.
Pardon me?
Yeah, where in subparagraph 1.2 he's referred to as the lead prosecutor.
That is correct.
And in paragraph 1.3, is it that one that relates to the Mlochwa matter, the Advocate Mlochwa's jurisdiction, the KZN?
It's the KZN jurisdiction. That's correct. It was partly Advocate Mlochwa and partly Advocate Noko.
Okay. I think the issue of the Katomena has been addressed almost adequately, and maybe let me leave it there, except for one thing that has caught my eye, and it is in LO1. Yeah. Before I take you to LO1, I think in the process of the presentation of evidence, there is a moment at some point where there was an indication that the suspects or accused, whatever their status, in the Katomena case, had a close working relationship with the DPP of KZN. Do you remember that, or don't you remember that?
I recall something that either Advocate Jiba or Advocate Chauke mentioned in one of the documents.
And that suggestion that there was this close working relationship between the KZN DPP and the Katomena suspects or accused, whatever their status. Would you agree with that suggestion that there was a close relationship between them?
I can't agree with that because I was not there at the time, but my recollection also is that what Advocate Jiba and Advocate Chauke, one of them or both of them, I'm not sure, was saying was that there was a close relationship between these accused or suspects in the Cato matter who were police officers and the prosecutors. I don't think they would mention the DPP.
Okay, I think that will be verified from the record. Thank you. Do you agree that Section 22(3) of the NPA Act does, in interpreting that provision, where the should I proceed? Have you found the
Yes, I have.
provision?
Thank you.
Where the NDPP is of the view that it would be looking at the relationship between the suspects or the accused with the prosecutors or even with the DPP of the jurisdiction where the offense has taken place, can, if he or she finds that it would be in the best interest of the administration of justice to bar the DPP of that jurisdiction that is affected from prosecuting the matter on the basis that the matter, it would not be in the interest of justice to allow her or him to prosecute the matter.
So on this scenario that you sketch, because it's still not established as a fact whether the prosecutors were compromised or not, or whether the DPP was compromised or not, and Advocate Molochwa can talk to that. But on the scenario that you sketch, there is a provision. What would happen in those circumstances if the national director is of the view that the DPP is compromised with regard to a particular case? Am I understanding correctly?
May I just interrupt you? I think you understood the question. I've not even asked it in the context of this case or, related to the facts. I've just said, looking at that provision in particular, do you agree or not that it does allow for the NDPP to bar the DPP in whose jurisdiction an offense may have taken place, to bar that DPP from prosecuting on the basis that there is this relationship which is likely to affect or to be seen to affect the exercise of the prosecutor's powers? Exactly.
I understand
Thank
the
you.
question well.
Yeah.
In those circumstances, in order to ensure that the DPP does not oversee that matter, has no legal authority over the matter, what the national director would be required to do in order to give effect to what you term as barring the DPP from dealing with that matter would be to remove that matter from the jurisdiction of the DPP KZN and place that matter in the jurisdiction of another DPP who will then have the legal authority to deal with that matter in his or her jurisdiction.
So you say, pardon, let me just get clarity on that. Will that happen, Advocate Batoi, even if an offense or offenses were committed far from the jurisdiction of this DPP who is now appointed to deal with the matter? If I'm just thinking of a scenario where, for example, number of transgressions or offenses, serious offenses, are perpetrated in KZN, and there are allegations that the DPP KZN is or may be compromised, and the NDPP then decides to move the dockets from the jurisdiction within which these offenses happened, in this scenario, KZN, and move these cases to Johannesburg so that they may be prosecuted by the Johannesburg or South Gauteng. I'm just giving an example.
Sure.
DPP. Does that happen at the practical level?
Chairperson, there will be no other way of dealing with it. If that happens, that will be the only option, even though it will cause inconvenience for witnesses. But the DPP, if the national director is of the view that the DPP is compromised, as the scenario that has been sketched, there will be no other option, because there's nothing that empowers, it would go against the constitutional framework to give power to another DPP to be the DPP in charge of a matter in another jurisdiction. So in as much as it would cause inconvenience, there would be nothing else to do. Alternatively, if the DPP is compromised, you would look at whether you need to remove the DPP, but it will have to be removed. The case will have to be transferred from the jurisdiction of KZN or any, whichever it is, into another jurisdiction, and arrangements will have to be made to deal with it.
I do understand the constitutional imperatives, but the Constitution is a document that must be given life. Now, if in the administration of justice, you cannot prosecute a case within the area of jurisdiction or cases, for example, in the Katomena matter, where a lot of killings happened in KZN, and the suspects are also from KZN, meaning that all witnesses involved will be in KZN. Will it be against the letter and spirit of the Constitution for the NDPP to exercise his or her control and direction in terms of the law to delegate a DPP from, say, Northwest to go and prosecute in KZN in a matter or matters in which he or she is not compromised?
Chairperson, in my view, it would be against the constitutional framework to give a DPP from another division any powers, prosecutorial powers, in respect of a case that is not in his or her jurisdiction.
Just thinking about the interest of justice.
Sure.
Public interest, interest of justice, the costs of having to move accused people to Gauteng or to Northwest, witnesses and people who have lost families to be relocated to Johannesburg for the case to be heard in Johannesburg, purely because the Constitution says you cannot delegate. I'm not sure whether it says that, but purely, let's even assume the Constitution is phrased in such a manner that it negates one DPP from one jurisdiction to go and perform a prosecutorial function in another. But looking at the broader picture, given the interest of justice, public interest, and all other aspects that I've mentioned, will that be in the interest of justice? To move that case, those cases, to Northwest or to Johannesburg, instead of moving one prosecutor to go to Durban or KZN and deal with those matters? Is that, will that be in the interest of justice?
Chairperson, as I've said previously, I'm not a constitutional law or an administrative law expert.
No,
My
just,
reading.
No, I beg your pardon, madam. I'm just talking at a practical level. I mean, I'm not taking the law here. Just common logic Simple logic.
With all due respect, Chairperson, it is about a constitutional framework. That is my understanding.
No, I'm saying put the constitution aside. Let us just talk about the day-to-day functioning. That if you were to decide as the head who has control over the administration of justice, and you are seized with such matters, and it appears that, and I'm not talking expediency, I'm just looking at the broader pictures of circumstances that may necessitate a delegation for someone to go outside his jurisdiction and perform that prosecutorial function. Will that be something that, apart from the Constitution, cannot be done? You wouldn't be having any discretion as an NDPP to say, given these circumstances, I will delegate Advocate X to go and prosecute in the jurisdiction outside his or hers?
Thank you, Chairperson. Chairperson, so I have to understand in your scenario whether you are speaking about a prosecutor, Advocate X, or a DPP exercising jurisdiction. It's an important distinction. And initially, the question related to the DPP, but what I'm hearing the Chairperson now speak about is someone outside the jurisdiction. So I need clarity on that.
Beg your pardon, I think let's confide it to DPP.
Thank you, Chairperson. So in that scenario, in my view, the DPP of another division cannot exercise powers in a jurisdiction outside that which he or she has been appointed to. And so a national director cannot ask a DPP to exercise these powers in an area outside of his or her jurisdiction.
Thank you.
Before we go there, the question is, when did you brief Advocate Nalani? His opinion is dated the 19th of October 2021. That is the date on his brief.
It's at 19 October 2021.
Yes, yeah. Yes, the question is, when did you brief him? Yeah.
Chairperson, we've been trying to get that information. We did get one letter that was written to him from my office, not from me, because the procedure to brief counsel is generally that the Legal Affairs Division, together with our procurement section, finance, would send the brief out to counsel. So we've got a letter, but I've still asked them, because the letter is just a one-pager, and we'll make it available, but I've asked them to get the actual brief that was sent to him, because this letter is not clear, in my view, about what exactly he's being briefed to do. Do we have that letter? Make some copies. So we did have copies of that letter. Counsel, I'm not sure if we've got that available, but as I said, I'm still trying to get the brief, because I think there should have been more information, in my view, that went to him. And this document doesn't seem to be the full brief or a letter that contains, in my view, sufficient information. But I don't know if it was the only thing that went to him.
But
We are
can
checking.
Can you assist about the date? If
Yes.
not the precise date,
What's the
then
date?
the estimated date around which period was
I
he
don't see
briefed?
oh, there she is. She's there. I think my colleagues are trying to find the letter. We did have a copy of it, so if we can get that and get the date, will be helpful. But we don't have it here. I have the electronic version, so in the interest of time, we will make copies. If I may, Chairperson, indicate
If you
it's the
have the
21st
answer.
of July, 2021. It's a letter addressed to, it's from the State Attorney's Office. Oh, no, it's addressed to the State Attorney. It's from the administration section in the NPA. And it is a letter that's sent to Advocate Nolane, informing him that his appointment has been approved to provide the NPA with an opinion on the implications and decisions taken by Advocate Chauke, the DPP South Gauteng. Please therefore, sorry, this is not to Advocate Nalane, it's to the State Attorney. Please therefore issue a brief to Senior Counsel. Such a brief should include assistance required in respect of both legal advice and consultation, any associated disbursements, they go on to talk about that. And it's dated 21st July, 2021. And it's signed by the Acting Chief Director of Financial Management in the NPA.
Would it be safe to say he was briefed during or around that period, the 21st day of July?
I would think it would be safe to say so on the basis of this.
Okay. And is there a way of ascertaining the precise date?
We are certainly trying.
Okay. I'm sure you'll find it. Now, let's go back. So it's around July 2021.
Yes, late July 2021.
I will not dwell much. I've already said on the Boyson's matter. Now on the Mdluli matter, SB5, that is your letter, page 232. 232. Paragraph 2.1, which reads, I have perused the NPS representations file relating to this matter. From a reading of the documentation contained in the file, I understand that Mdluli was arrested in the beginning of 2011, where after a decision was made to indict him and 3 others in the High Court for several charges, including murder, attempted murder, intimidation, kidnapping. The trial would have commenced in April 2012, but following representations, you decided to withdraw the charges and a formal inquest was held. Now, the representations, the NPAS representations file, in fact, those representations, they are in the NPS file.
That's
right?
correct.
And where do we find them in our bundles?
They're not in the bundles.
They are not in the
We will
bundles.
make arrangements to get that file.
Okay. So then that increases the list of exhibits. It will be noted. I beg your pardon?
Say the team are making a note and we'll
Yes,
definitely
yeah,
get that.
that's fine. Right. Now I will proceed to the matter of Karima Brown. Right? Miss Karima Brown is the complainant. You invited Advocate Chauke to give you further information or to comment, and his reply is in SB6, pages 255 to 256, as I have said, but in particular at paragraph 58 to 59. Are you there? The
Yes, I
paragraph
am.
58 is in page 255.
Mhm.
Is that SB6?
SB6, yes, SB6, page 255. The paragraphs that I will read into the record is paragraph 58 and 59. And that was the complaint where Miss Karima Brown had complained to the NPA about the conduct of of Advocate Chauke, and Advocate Chauke had reported her to the Broadcasting Complaint Commission of South Africa,
Mhm.
and where he was not satisfied with the decision, then he appealed, and his appeal was successful, according to this record. It reads, I subsequently reported her conduct to the Broadcasting Complaint Commission of South Africa. A copy of my complaint is annexed here too as Annexure AC1. Where do I find that AC1, the complaint of Advocate Chauke against Miss Karima Brown's conduct?
It would have been attached to his letter. We'll check the files and get that. Is it attached?
Yeah.
We'll get that document.
You'll get that document. It's AC1.
Mhm.
At the BCCSA hearing, the issue of her being intimidated by me arose, and the commission found that there was no intimidation at all. The BCCSA wrongly made a finding that there was no breach of the code and dismissed the complaint. So the BCCSA found that there was no intimidation that arose from Advocate Chauke, and further, then it made a finding that, well, notwithstanding there is no breach, there was no breach of the code. Now, he appealed this decision, and he was successful in his appeal according to this document. And the finding of the appeals committee or the appeals panel, whatever the name is, was made on the 10th day of May 2021. The appeal board ruled in his favor. And attached is copy of the ruling. That ruling is not in the record. Can we also have copy of that ruling? It's described as AC2 in page 256.
Certainly.
Right.
Yesterday we said that he cannot go to them or his issues, those issues that do not fall within the aspects of the complaint. I'm not sure, but they went in the opposite. The issues of Brown, etc. If they are relevant, that they take it there.
Yeah.
Where you going to?
Right. Thank you. Thank you. And you say it will be made available. Right.
I do.
Thank you. And now let us go to the, maybe let me finish of this, because the next one will be Brian Hlongwa, and then it will be Duduzani, and then the briefing of Advocate Nalani. Let's go directly to the Advocate Nalani's opinion. As I mentioned, I've not only confined these questions to the matters of Ndluli and Boyesins, and I have done so because I am looking at the opinion or the brief, in fact. I think the brief, much as we do not have the brief, and that opinion of Advocate Nalani is found in LO1 from pages 30. LO 00030. Are you there?
030, yes.
Yes.
That's
Yeah.
correct.
Yes. And now I'd like you to turn to page 00034. Right? This introduction, or rather, the opinion of Advocate Nalani in itself, it's a fair reflection of the brief that was given to him. Is that correct?
It looks like it, certainly.
It looks like it.
Yes, he's been requested to advise that, and I mean it speaks for itself.
Okay, so you confirm that it is
Yes,
correct?
I do.
Right. Now, when one looks at the paragraph 3 on page 34, it says, I'm requested to advise whether Advocate Chauke is guilty of any misconduct, has failed to adhere to the prosecution policy, or whether he is, on account of his incapacity to carry out his duties of office efficiently, not a fit, a proper person to hold the office of Director of Public
I think it
Prosecutions.
should read fit and proper. There might be a mistake there. Fit and proper.
Yeah. And in paragraph 4, he says, if warranted, I am briefed to draft the necessary submission to the President, advising on the prospect of success in such inquiry into fitness to hold office. So is it correct to understand this brief to be a brief that is requesting for an opinion on the conduct of Advocate Chauke, and also a brief that in the event that the opinion would be that the inquiry would be justified, then he should also draft the necessary submissions to the President, advising on the prospect of success in such an inquiry into fitness to hold office.
So you are correct. What would happen in these circumstances is that when we brief counsel, it's not uncommon for us to make sure the brief includes a second step, so that there's no need to go and draft another brief and go through the whole procurement process again, that the office would add that second step in case it's necessary to avoid those logistical issues. That is correct.
Yeah. What is correct, or what I'm actually highlighting, is the fact that this brief is a brief about opining on the conduct of Advocate Chauke, and the second leg being to draft the representation's letter to the president should he opine accordingly.
It's not his decision to draft the letter should he opine that. It would be our decision in the event that I am of the view that the letter needs to be drafted, having considered the matter, then we would request him to do that.
Right. So he would be, in the event, had you decided upon receipt of his opinion, had you decided to refer the matter to the president, then he would also have been briefed to draw the letter of representations.
That was always, yes, it's a possibility. We add it, as I say, we add it in briefs. It doesn't mean you have to go back to that council. You could decide you want another council, but it is included in that to avoid unnecessary procurement if that stage is reached.
Yes, I do not have briefing a different council in mind when I ask this question. Now, let me take you to page 37 of that opinion. Now, paragraph 14 says the decisions concerned involve the following matters: General Boyson's prosecution, Mdluli murder charges. How many charges were involved? Murder charges were involved here.
My understanding, it was one murder charge. In fact, it was one murder charge and an attempted murder and other charges.
It was one murder.
It was one.
And complained by the late Miss Karima Brown, the state versus Brian Hlongwa, and the state versus D. Zuma. Now, I will not dwell or even deal with it at all. That one of General Boyson, that one of Mr. Mdluli or General Mdluli. With regards to the conduct of Advocate Chauke in respect of the complaint by Ms. Karima Brown, it is correct from the evidence that has just been led that as at the 10th day of May 2021, the appeals board or appeals committee of the broadcasting complaints had cleared Mr. Advocate Chauke of misconduct, and you were in possession of that information then. The clearing, the ruling was attached to the reply that was sent to you on the 28th day of April. And it is also correct that notwithstanding that he had been cleared and his complaint of breach of the code had also been confirmed, you nevertheless sent this complaint as part of the brief to Advocate Nalani in or around July, about 2 months later. Is that the case?
That is correct.
And the matter of State versus Brian Hlongwa, that one too,
Sorry, the matter of?
State versus Brian Hlongwa, on page 37. We are in page 37.
Mhm.
Advocate Chauke had already replied to your inquiry on the 28th day of May regarding that. And you nevertheless still included it in the
Mhm.
brief for opinion from Advocate Nalani SC.
Mhm.
That is correct.
That's correct.
Yes, thank you. It will help just to confirm on record. And that was 2 months after receipt of the reply from Advocate Chauke.
That is correct. I take it if you're going to draw inferences from this, you will ask me further questions. Whether I, in the time,
Asking which question are you answering?
oh no, that was just a comment.
Oh, okay. Thank you. And paragraph 14.5 is the case of State versus D. Zuma. And it is correct that by this time, this case had been finalized. Is it correct?
I'm not sure that it was finalized, but I think the deep, well, not the, I know that the previous national director had decided to prosecute, had
Okay.
overturned Advocate Chauke's decision.
Yeah, maybe, yeah. Let me just give you the brief background. And that brief background to that matter appears on Advocate Chauke's reply to your letter. Ne? And that reply appears in SB 6 257 to 259. SB 257. In fact, to be specific, yes, it's 257 to 259. Okay. Now, just the background as appears here. The background of the matter is that I'll start off at paragraph 64. This case was referred from Randbeck to the Director of Public Prosecutions, and the matter was handled by Advocate Galeka and Advocate Mapiri, a senior state advocate.
May I clarify, my sister, you're referring to the Hlongwa matter?
I am sorry about it. I'm on SB 6257. It is the Duzani Zuma matter. SB 6257.
Yes, thank you.
And I'll start with paragraph 64, which reads, That was the response of Advocate Chauke. The matter came through to this office from the Senior Prosecutor of Randburg, Mr. Yusuf Baba. The work allocator at the time, Advocate Fanzil SC, allocated this matter to Advocate Mapiri, a senior state advocate, and Advocate Koleka Galeka, a deputy at the time. I think she's the current public protector, to be checked of same. On 9th July 2014, the latter finalized, that is Advocate Galeka finalized a decision and decided that an inquest should be held. She informed me of such a decision. And paragraph 65 confirms that the matter was then returned from the inquest, and it was then sent for consideration on whether to prosecute or not. And they both, Advocate Galeka and Advocate Godwana, considered the matter and then decided to decline to prosecute. Paragraph 66, Advocate Chauke looked at the docket and satisfied himself that the matter, much as there was a prima facie case, but there was no winnable case, and as a result, he says, I was satisfied that there were no reasonable prospects of successful prosecution in the matter, and accordingly endorsed the decision not to prosecute. So he was endorsing the decision of Advocate Galeka and Ngodwana. Then in paragraph 67, Advocate Sean, Advocate Abrahams and Nzinyat then reviewed Advocate Chauke's decision and instituted the proceedings. And the matter then went to court, and the case was then finalized with an acquittal. Now, this happened. The review of Advocate Chauke's decision was done in 2017, and it would help to get information as to when, in actual fact, I enclose here with, in paragraph 69, Advocate Chauke is enclosing an explanatory note from the logistic manager because certain information could not be obtained because of the fact that according to policy, I think it's the NPA policy, certain documents get destroyed after a particular period. So we would like to get a copy of that explanatory note from the NPS, AC 14. Now, the reason why
I beg your pardon, my sister. Are these documents in 69, for instance, in relation to paragraph 67 pertaining to Mr. Zuma matter? Because it seems to me, and Advocate Batoi can clarify, paragraph 67, 68 seem to relate to partly, I must say partly, to the Zuma matter. And that document that my sister refers to, AC 14, is it in relation to the Zuma matter? Because I asked, and I suppose my sister will guide us as to the relevance of these aspects, because the Zuma matters, if I remember from the opinion of Advocate Nalani, he advised that there be no referral in relation to all those matters, the Zuma matter, the Hlongwa matter, and in other words, he confined his opinion to the Katomena and the Mdluli matter. And I'm not sure to what extent this document may be of relevance. Maybe my sister can maybe guide you in that regard.
Right. Thank you, Chair. The purpose of the questioning around these matters that were referred for opinion from Advocate Nalani, the importance of that to me is the time period to say, as at July 2021, when Advocate Nalani was briefed, he was briefed with the knowledge that the Karima complaint had been decided upon and Advocate Chauke had been exonerated. The Brown Hlongwa matter, Advocate Chauke had responded to the query, and by then you had full information of the response. And the Zuma matter, at the time when the Advocate Nalani was briefed, it was already known to the witness that the decision not to prosecute had been made by Advocate Galeka and another, that the decision of Advocate Chauke had been reviewed, that the matter had gone on trial and finalized. It's about the timelines to say, as it may, this information was there. And notwithstanding, the matters were nevertheless referred to Advocate Nalani for an opinion. That is the purpose of the questions. Thank you.
So am I to assume we are sort of looking at the appropriateness of my conduct in this process in terms of the steps that I took?
I am looking at the times as to what to make of that information is something that will be dealt with.
I'm just trying to understand so that I can answer properly whether there's any inference that I acted improperly, but I'll certainly try to explain it in the best way that I can. I certainly didn't have any intention of acting improperly in this matter, but I will explain as best that I can. So yes, this information was before me, and it's included in the brief to Advocate Nalani. Let me explain that, again, it must be understood the context within which I took office as the National Director. I was dealing with a period in the history of our country where we had allegations of state capture across government, including in the NPA. The Zondo Commission was doing its work, and there was a lot of information that suggested that people in the NPA were complicit in state capture. As a responsible national director, I wanted to make sure that I needed to understand whether there was any truth to those allegations or not, and in the event that there was, if there was appropriate action that a national director should take. So in these particular cases, but for Karima Brown, the other two persons involved, Brian Shlongwa and Duduzane Zuma, were very prominent persons. Brian Shlongwa, I think at the time, was the MEC for Health in Gauteng. And I should add, he is now facing those charges. So I needed to ensure that decisions taken were properly taken, notwithstanding the report that I got from Advocate Chauke. I wanted to go the extra mile and have these things properly checked out. So that is the reason why Advocate Nalane, and I'm casting my mind back to the time. I don't know if there was any other information before me at the time. I don't know. All I have are the documents in front of me now, and I'm trying to think about what could have prompted that decision. So that is the reason why they would have been included, is to make sure that all possible bases were covered. Well, I'm not sure it would have been all with Advocate Nalane's opinion, but certainly to add an extra layer of checking. And that is what I did. Of course, when his report came back, I didn't proceed any further with the 3 matters, but just the 2.
Advocate Nalane's opinion. Upon receipt of the opinion of Advocate Nalane, did you peruse the opinion and satisfy yourself as to whether it addressed all the information that you needed?
I certainly did peruse it at the time. There were clear gaps in his opinion at the time, which I think he himself mentions.
May I just request my sister to park that question or clarification? It's tea time. I propose that we take a tea break and return at 11:30. Beulah Jen. Good day, everyone. Good day, Advocate Batoy. Good day, Advocate Chauke. Advocate Moshamayane, you will proceed, but my sister is going to deal with a few questions in conclusion, and you will then take it from where she ends, or rather, where you ended yesterday. Advocate Batoy, you are still under oath.
I do, Judge.
Thank you. Advocate Batui, I think the last question that I asked when we adjourned related to the opinion of Advocate Nalani.
Yes, that's correct.
That is, we were at a point when I was talking about whether you had read the opinion or not, and you said you had,
That's correct.
and you said you also observed the shortcomings in the opinion, right? And those shortcomings that you observed in the opinion, what did you do with them?
Well, at that point, we had obtained the report, and I think I need to go back to my affidavit that deals with what happened after that, so that it will address the question. And I can also contextualize it because I am trying to cast my memory back a number of years. It's my affidavit. I think it's around where we have been for the past couple of days. We're dealing with the process for the referral. It's on paragraph 165 at page 70, Chairperson. It's in my affidavit.
Yes.
So Chairperson, I had looked into those matters. I had got Advocate Nalane's report. At that point, the Zondo Commission was doing its work. And I had really hoped that the Commission would complete the piece of work relating to the capture of the criminal justice system, including the National Prosecuting Authority. And the Commission will make findings with regard to the proprietary or otherwise of people within the NPA. And so when I received the Nalani report at that point, I didn't do anything with it. I waited for the Zondo Commission, and it completed its work. The Nalani report was in October of 21. The Zondo Commission completed its work the following year in April. Well, that was the final report that was delivered in April. I realized then, very disappointingly, that in the sense that I was hoping that the Commission would make findings either clearing NPA members or finding that there's some impropriety, in which event I would be able to decide what to do with it. But the Commission didn't go into any of that, and apparently due to my understanding is timeframes, etc., time limits and budgets, etc. I don't have first-hand knowledge of this, but it's what was available publicly. They did not make any findings, either for or against. I was then in a situation that I had to think about, what do I do? I had the Nalani report, the opinion at that point. And so in July then, I sent that opinion to Advocate Chauke of 2022. That's in paragraph 168 of my affidavit. and asked him to provide me with reasons why I should not request the president to establish an inquiry into his fitness to hold office. And my letter is attached. So to answer your question, at that point, that is what that was the process that was followed after that.
Okay. So when you sent the copy of the opinion, you had already picked up their shortcomings, or did you pick that up later?
I mean, he had mentioned it in his report, so I would have been aware of certain shortcomings at that point.
Right then, thank you. That concludes my questioning. Okay.
I
Yeah.
take note.
Yeah, just understand that when we ask questions, you ask questions in order to get, at times, even a holistic picture of what has been happening. So that at the end, when you are sitting in your office or elsewhere, we should be able to carry out our mandate to finally.
I think at this rate,
With
I will
ease.
retire in this commission in the end of January.
Well, that's all. Thank you.
Thank you very much.
Before you begin, Advocate Mutlamuyani, just bear with us. We have taken a bit of time to clarify a few aspects since this morning. How did this matter of the Katomena land at the Zondo Commission? Is my reading correct that Advocate Boyce, or rather Major General Boyson, was the one who complained to the Zondo Commission based on allegations of state capture of a certain member of executive, certain minister?
Chairperson, I cannot say how it landed on the Zondo Commission table from first-hand knowledge. What I am aware is that about this case is that it emanated in KZN. There was a case against a person called Toshan Pandey, who's a businessman in KZN, and that case. There were allegations in that case. The case is currently in court. He's been charged subsequently. That case in KZN was against Toshan Pandey and the commissioner, the provincial commissioner of police at the time. I can't recall the name. Was also, if I'm correct, one of the accused. I'm not sure, but there was also a police officer, and General Boyson was investigating that Pandey matter. He was the investigator, and the matter was there were allegations, and I'm sure he'll be able to testify a lot more to this. There were allegations that Pandey was connected, highly connected, and that the investigation by Boyson was not seen in a favorable light and had to be stopped. The charges against Pandey were subsequently withdrawn in KZN by Advocate Noko. And I should say that I even wrote to Advocate Noko and asked her for various reasons for various decisions. And I was at the point of referring that matter to the president when she resigned. But the Pandey matter was kind of central to this, and the allegations of connections to high-placed politicians and Boyson's involvement in that investigation. That I know, and I'm sure there'll be evidence presented to that effect, but how it exactly got to the commission and who took the complaint there, I can't say.
How Advocate Chauke was called to make statements before the Zondo Commission?
I'm not aware of that, Chairperson.
You're not aware of that? I think it maybe when Advocate Chauke testifies, because when I read his statement, it appears that he was asked to appear before the Zondo Commission, and he subsequently made a statement, but that's a matter for another day.
Thank you, Madam Chair. Advocate Patohi, you will remember that yesterday we ended up at paragraph 179, where reference is made to Hali SC's and Wenzel's opinion.
That is correct.
Now, when you were being asked questions for clarification, it emerged that there was an annexure attached to Advocate Hali SC's and Wenzel's opinion.
There were a couple of annexures. I can't remember exactly how many.
I'm specifically referring you to the annexure, which was an affidavit of Colonel Kubo's DeMeyer rule of cell.
That is correct. I did mention that in my testimony.
Now, may I direct your attention to, before we revert to the annexure itself, to LO, it's LO4 bundle, in which Advocate Hali's and Wenzel's opinion appears.
The page number?
The page number is LO001049. In other words, 001049.
Yes, I see that.
Before you get to the annexures, to that council. Yes, indeed, we were at paragraph 179, and my recollection is that my sister Ramachacha was asking you a question about the third sentence of 179 that reads, they did so and concluded that there was a sufficient basis to include Advocate Chauke's conduct in the Mdluli matter in the recommendation to the president, I paused there. But the point that she was making, and I would like you to clarify it for me, relates to the sentence itself. They did so and concluded. When you testified, you inserted, I concluded that there was a sufficient basis. The insertion from your evidence does not appear in the sentence itself, and this may be the question of semantics. I run ahead of myself and say it may be a question of semantics, because when you say they did and they concluded, shouldn't the sentence read as follows? Anyone who reads it like that will probably say, they did so and they concluded, because you refer to they. And you said yesterday, they did so and you concluded, and I concluded. Would you clarify that for me?
Yes, thank you, Chairperson. I thought I clarified it yesterday. I will repeat what I said and what I recall I said. When the evidence leader took me to this paragraph, he said to me not to read it verbatim, but to talk to the paragraph. That is the way I understood it. And that is what I was doing. So when I said they did so and I concluded, I was not inserting anything anywhere. I was speaking about what happened after this report, this opinion was obtained. So it's not, so to be clear, I was not reading, I was talking. And that is why I mentioned it like that. And then I was questioned about it by Madam Ramachacha, about the inclusion of the I, and I said that, and that is in fact the position, Chairperson. Yes, that's correct. Chairperson, yes, I was asked this question as well yesterday, and I said it should read, they did so and concluded. That would mean the conclusion is talking about the authors of the document, the way it's framed here. It would mean they did so and they concluded that. Well, that's, yes, that's from the context.
So it is the authors of the opinion who made a conclusion.
That's what appears from there, Chairperson.
No, Counsel, in fairness to us and yourself, this is your affidavit.
That is correct,
And
Chairperson.
it cannot be like we are forcing you to say something that you have not said. You said this under oath, and I'm asking you to clarify what appears from your own affidavit. If there is an insertion of I, if there's no insertion, it's understandable. But my reading of that sentence is that the people who wrote an opinion concluded, and you are saying that's exactly how it should read.
Chairperson, I must read that opinion again carefully to make sure that that is what in fact they concluded, because I'm really trying to, these affidavits were put together very quickly. I tried to explain. We stayed up till midnight on the Friday and uploaded it at 10 to 12 at midnight, the day it was due. So we went through it really quickly. We wanted to adhere to the very strict timelines. And so I would want to read that opinion again before I say that that is in fact what they concluded, because that is, I have to read it before I say conclusively that is what they concluded.
Advocate Andrew, let's not go around seconds, please. This is your affidavit under oath.
That's correct.
And you know, as a lawyer, what that means.
I do.
We are addressing the contents of your own affidavit. It may well be that it was prepared in haste. But when you append your signature under oath to the document, it means you believe the contents of what you are saying in that document.
That's correct.
Now I'm saying to I beg your pardon. I will try to capture what I said earlier, that this is your affidavit under oath, and we need clarity on the contents of this sworn statement about paragraph 177, line 3. What I want to ascertain from you is whether we should read this sentence as it appears that open code. They did so and concluded. If my reading is correct, it means they who prepared that opinion then made a conclusion, not that it is you who concluded.
Chairperson, that's the way it reads. And that is, in fact, the way it reads.
That's what it is.
I'll have to read the report again to make sure that is what it is.
No, Council. That's what it is, that they did so, the authors of the opinion did so, and they concluded that there was a sufficient basis, blah, 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 blah. This is what they concluded, not that you concluded.
Chairperson, as I said, when I prepared this affidavit, I'll be honest with this court, I didn't read any of the annexures. These annexures have been read by me years ago. We prepared this under extreme haste. I did not read any of the annexures. I've been reading them subsequently to try to prepare. And that was the position when I signed this affidavit. And I agree, it reads as they did so and they concluded that there was sufficient basis, but I will have to look at it to make sure that what I signed to was in fact, accurately captured.
Council, it is helpful to be very, very concise and not end up saying things that you don't want to say. When you say you did not read this document, it may mean a lot of things. So please just answer the question and not elaborate on what I'm not asking for, because it's a simple thing. Should we read the sentence as it is, or do you want to correct it under oath? Because you're still under oath. Yesterday, a question arose as to whether, and I'm asking this for the last time, whether it is you who concluded, it's just as simple as that, or whether it is the author of the opinion or the authors of the opinion who made a conclusion.
Chairperson, firstly, I want to clarify, I read my affidavit
I know
and I signed it. Yes.
The question is it you who concluded or the authors who concluded based on this sentence?
Chairperson, the reason why I'm emphasizing I read my affidavit is because the chairperson said that I did not read documents. So I wanted to make sure clear that I read the affidavit, but not the
It
annexures.
is you who earlier on said that you did not read the annexures.
That is correct. So I wanted to clarify it's only the annexures, not the affidavit. Chairperson, on your question, yes, I do say in my affidavit, they did so, and as it reads, they concluded that there was sufficient basis, but I will have to read the annexure again to make sure that that is the correct, that what I put there is in fact accurate. I can't correct it now. I might ask to correct it at a later stage if it is indeed incorrect. But at this point, I don't have any reason to think it would be incorrect.
I don't know how you correct some statement you made under oath, because you bound yourself to the correctness of that because you signed it under oath, but that's a matter for argument.
Chairperson, I did explain the
You may
circumstances.
proceed, Advocate Mhlamunyan.
Chairperson, I did explain the circumstances under which we signed this affidavit. They were really tight time constraints.
May we proceed, Council?
Thank you, Madam Chair. Advocate Batohi, I was referring you earlier to Advocate Hali SC's and Wenzel's opinion, and I said it is contained, it starts from from page 001047, and I specifically refer you to Paragraph 5. On page LO 001049, where the authors of the opinion deal with the summary of the crucial conclusions against Advocate Chauke. Do you see that?
I do.
I'm doing this for the simple reason that you were asked as to whether you considered any evidence before you could refer the matter to the president. Now, before you answer that, please read paragraph 5 into the record.
I will. Before delving into our process of reasoning and the evidence to support that reasoning, there are preliminary facts and observations we should set out to better understand what is to follow. These are all derived from the affidavit of Colonel Kobus de Meyer Rulofse, who had investigated the charges against Lieutenant General Mdluli. We attach a copy marked A.
Now, when you referred the matter,
I beg your pardon, Counsel. Where are you reading? Are you at Advocate Halley's opinion or at 01047 to 1 LO 0149?
Madam Chair, we are on 001049, specifically at paragraph 5 there.
LO
LO4,
LO4.
yes, page LO 001049. That's where Advocate Patohi had just read.
Yes, thank you.
May I proceed?
You may proceed.
Now, when you sent the referral to the president's office, had you taken note or had you read, so to put it, this affidavit
Yes, and the other annexures as well, but yes.
and the
I
other
did.
annexes as well?
Yes.
Was this affidavit containing the evidence that you said you took account of?
Yes, a summary of the evidence.
Now, Madam Chair, that affidavit is part of the record. It is contained in bundle RM3. On page, it starts on page RM 00748. It is a very lengthy affidavit which ends on page RM 00814 and deposed to by Kobus de Meyer Rulofse, Colonel Rulofse, on the 5th day of April 2012. It will be marked as an exhibit, Madam Chair. It's already on the record. It will, in due course, be marked as an exhibit.
Yes, thank you.
Now, in the course of questions that arose from the panel members, the issue of provisional withdrawal as against a withdrawal was dealt with. Now, you may want to perhaps clarify what it really means. And in this regard, in order to clarify what it really means, what provisional withdrawal of a charge or charges as against a withdrawal, you can go to Branch JA's decision. Or
Beg your
judge,
pardon, I'm trying to link that question to the statement of Colonel Rolofsen. Is it linked or is it separate?
it's a
question?
separate. We're done with the issue of Colonel Ruloff's, Madam Chair.
Yes, you may proceed.
Go to CL on page 368, where you'll find the judgment of Branch JA. CL2. Are you there on page 368? And reference is here made to paragraph 34.
I am.
Right. Continue to read paragraph 34 into the record in order to explain provisional withdrawal as against withdrawal. Paragraph 34
Of the SCA judgment.
of the SCA judgment, that's Branch JA's judgment, and it's on page CL 00368, and the bundle is CL2.
Yes, thank you.
You may proceed.
Thank you. Chairperson, I did explain that there was no real difference between, there was the effect of a provisional withdrawal and a withdrawal was the same. I'm going to read what Branch JA says about that into the record. At 34, he states, the withdrawal of charges by Nkabinde and Chauke, so the NDPP's argument went, was covered by Section 6A and not by 6B. In consequence, so the argument proceeded, these decisions were only provisional and therefore not subject to review. Although I am in agreement with the premise of the argument that both decisions to withdraw were taken in terms of Section 6A, my difficulty with its further progression is twofold. The first, I see no reason why, at common law, a decision would, in principle, be immune from judicial review just because it can be labeled provisional, however illegal, irrational, or prejudicial it may be. My second difficulty is more fundamental. I do not, and this is the important part, I do not believe a decision to withdraw a criminal charge in terms of Section 6A can be described as provisional just because it can be reinstated. It would be the same as saying that because a charge can be withdrawn, the institution of criminal proceedings is only provisional. As I see it, the withdrawal of a charge in terms of Section 6A is final. The prosecution can only be recommended by a different original decision to reinstitute the proceedings. Unless and until it is revived in this way, the charge remains withdrawn. Thank you. That is my understanding as well. I should say that
On
is the
this
position.
reading, if I may clarify, that which the SCA says in this paragraph, does it mean that a withdrawal which is final, does it bring to an end the prosecutorial decision, or rather the prosecution, if I may put it that way? In other words, I'm not sure whether I'm putting it clearly for you to understand. Bringing a matter to an end in the form of saying nolle prosecute or not prosecuting, a decision to prosecute or not to prosecute. So I'm using those concepts. Whether what Branch JA says in relation to the withdrawal being final, is it akin to saying a decision not to prosecute or bring prosecution to an end? Because it can either be prosecution or not prosecuting. So if you withdraw, does it mean that it is the end of that matter?
Chairperson,
In the
it,
sense that it is not going to be prosecuted. It has been brought to finality.
Chairperson, it does not mean that, and that is not, in my understanding, what Branch JA is saying. It is final in the sense that it remains withdrawn until you decide to institute the case, reinstitute, re-enroll. That is correct, Chairperson.
Thank you for clarifying that. You may proceed.
Thank you, Madam Chair. We will then leave that aspect and go to the issue of delegations of authority. Remember, you were being asked as to who has to issue out delegations when prosecutors straddle, go to another jurisdiction. Now, there are delegations issued here, and they're not part of the record, not so.
That is correct. Oh, I'm not sure if they're not part of the record, but I know there are delegations that you have.
Oh, my apologies. They are part of the record. They are part of the record. And let's go to B1, page 00144 to page 00145. Madam Chair, they will later be.
Helpful if you tell us the volumes. What volume is that?
It's volume B1. Yes.
Volume B1.
On page 144B, 00144 is the delegation of Silot Leston Maema by Advocate Nomngobo Jiba. And on the next page, B00145, appears the delegation of Kulelani Raymond Matenjwa by Advocate Nomngobo Jiba. They will later be be marked as exhibits, Madam Chair, but they are on record. Are you having them in front of you?
Yes.
Can you confirm?
Yes, I can confirm that.
Okay, please confirm that on page 144 and 145.
I do.
Now go to page, still on B1, 00470. Are you there?
Yes.
It's a delegation
Sorry, 004?
470.
It's 469 as well.
Yeah, start with 469. We're starting with 469. 00469 B1. My apologies, it's B2 actually. B2, Madam Chair, and Madam Aloimere. 469 in B2.
I note that you refer to these letters as letters of delegation. The Act speaks of authorization. Is it, shouldn't we stick to the letter, to the word used there, or in the letter itself? Is authorizing,
It's authority, yes, authorizing.
because it may well be an issue whether the DPP has the powers to delegate. It's another matter. But let's use the wording used in the letter. Even in the heading, they use authorization.
Yes, that should
I
be.
see you refer to them as delegation letters.
Loosely like that, but you're correct, Madam Chair. They should be referred to as they appear in the Act and in the document itself. Let's go back to 00144. The authorization by Nomnqobo Jiba to sell lot less than Maema to exercise the powers in section 21 in KZN. Can you confirm that?
I do.
Go to the next one on page 145, B1, page 00145. That is the authorization by Advocate Nomnqobo Jiba to Kulelani Raymond Matenjwa.
That's correct. And they are both dated the 8th of March 20. They are both dated 8th of March 2012.
Now, let's go to the next one in B2, bundle B2, page B 00469, being the authority to institute and conduct criminal proceedings by Cyril Simpiwe Mlojwa to Mahlubi Ntlakaza. Can you confirm that?
That's correct.
What was the date?
5th of June 2012.
It's not the first.
It's with effect from 1 June 2012, but it's dated 5 June 2012.
Okay. Proceed to the next one on page 470, B00470. In B2 00470, whose authority is that?
Patience Moleko, granted authority by Cyril Simpiwe Molochwa, the acting DPP of KZN. Also dated 5 June, the authorizations from the 1st of June.
The next one on page,
Who is Ntlakaza?
the question from Madam Chair is who is Ntlakaza, Mahlubi Ntlakaza?
I can't recall. I'm not sure if he was one of those. He was part of the team under Advocate Maema, but we can check the document.
Prosecution team under the leadership of Advocate Maema.
Yes, I think his name was also there in the list.
Is he a prosecutor, director, or DPP? What is he? Mahlubi?
Definitely not a DPP. I don't know what his rank would be. Below, it will be below that, either prosecutor, senior, or a deputy. I'm not sure.
Do you know from which province? Is he from?
No, Chairperson.
Madam Chair, maybe for convenience and for cross-reference, their names, the names of the Katomana team of prosecutors appears in bundle S in annexure SB3, which is the internal memorandum of Advocate Dikok and others. Their names appear there. The team's names appear there. It's not clear here. It's only stated as Advocate Mahlubi. Advocate Mahlubi Ntlakaza. It ends there. But we know, Madam Chair, that Advocate Selo Maema, evidence has been led here that he was from Northwest Province.
That's the only one we know. That's the only one we know that he was from outside KZN, by virtue of the fact that certain crimes were committed in the Northwest. That's why, Council, I'm asking you about Advocate Ntlakaza. Was he from KZN or was he from elsewhere? You will let us know at a later stage.
Chairperson, if I may, none of these colleagues could have been from KZN because they were all being granted authority to prosecute in KZN. That means they are not KZN prosecutors.
Futan. My colleagues are advising me, Madam Chair, that Advocates Matenjwa, Ntlakaza, JJ Mlochwa, Pumeza Futani were all from South Gauteng. Except Futani, that's right.
Even Advocate Mlochwa?
Yes, JJ Mlochwa.
JJ,
There's
not
another
the other
Mlochwa,
one.
not the other one from KZN.
Yes, I know that.
Yes. And Futani was also from Gauteng. But not South Gauteng.
Thank you. It helps, Councillor.
Thanks, Madam Chair.
Chairperson, we need to clarify that and check that it wasn't South Gauteng.
About
My
which one?
understanding is that the four of them might in fact be from South Gauteng, but that can be easily clarified.
Including Futani.
Yes.
You may proceed.
Now, go to the next page, Advocate Patohi, where you will find authorization by Advocate Cyril Simpio Mlocha to Pumeza Futsani. Do you see that?
Yes, I do. It's the same authorization dated 5 June with effect from 1st June 2012.
In the same,
Authorization to conduct prosecutions in KZN.
in the same bundle before, go to the next page, 00472, where you'll find authorization by Advocate Mlocha to Advocate Jabulani Mlocha. You see that?
I do. It's the same authorization and the dates are the same. And signed by Advocate Mlochwa, Acting DPP KZN.
All these were authorizations to institute prosecutions in KZN
That is correct.
by prosecutors who were not stationed in KZN
That is
from
correct.
from another jurisdiction, in this case, South Gauteng.
Yes, that is correct.
Madam Chair, maybe to get clarity on this, on Futsani, I am informed that Futsane was at the time the chief regional court prosecutor in the magistrates court, I believe Johannesburg. And Futsane, I'm told, was a lady.
Advocate Nkabinde, you've just said they were all, these are authorization for all these members who were all from South Gauteng, but earlier on you said some were not from South Gauteng. Has that been
All but one.
changed? All but one.
Yeah, all were from South Gauteng. It was only Maema, Advocate Maema, who was from Northwest. Now, another point of clarification is that Miss Futsane was a lady who was a chief regional prosecutor at the Magistrates Court, Johannesburg. Now, these authorizations will later be marked in due course, Madam Chair, as exhibit.
Thank you, Council. You may proceed.
Advocate Bardo, he will leave. We now leave the issue of authorizations and get on to before we leave them. Is the validity of these authorizations in issue?
No, they aren't. I mentioned in the testimony that they had received, these prosecutors had received delegated authority to prosecute in KwaZulu-Natal, either by the DPP or by the National Director, and this confirms that.
What is
So-
in issue exactly?
Is the fact that Advocate Chauke had no authority to exercise powers in KZN.
Now, let's leave that aspect and get onto the next one, which is the issue of evidence or no evidence, as you stated in your evidence. You have been asked questions in clarification about evidence or no evidence. Now, you'd want to clarify that position, that issue, by getting to the report of the internal memorandum, rather, of Advocate de Kock. Is that correct?
That's correct.
Now go to your paragraph 182 before you do that. Your paragraph 182 of your affidavit. You may read it into the record.
Ultimately, what struck me is that in the Boyson matter, Advocate Chauke had vigorously pursued criminal charges against Boyson when there was, as found by the High Court and in my assessment, no evidence against Boyson. And this is the aspect that I want to clarify. I continue, but in the Mdluli matter, had adopted the opposite stance and declined to prosecute, instead referring the death of the victim in that case to an inquest when there was strong case against Mdluli. I do know the chairperson asked me about this particular paragraph, and we will deal with it now.
Go to SB3, Annexure SB3.
Let's get the correction. I did not ask about these paragraphs. I was asking about the terms of reference, in which you find a common thread of the allegation that Advocate Chauke did what he is alleged to have done when there was no evidence.
Right.
Now, that common thread runs through the terms of reference in relation to the allegations leveled against him. You might have wanted to answer that question in relation to this paragraph.
Thank you. Thank you, Chairperson.
Go to the DCOC panel internal memorandum, which is SB3 in your,
Are you done with paragraph 182?
it's linked to what she's going to explain, the no evidence, insufficient evidence issue. And
You are going to a new matter?
no,
It's linked to
it's
this.
linked to it. It's
Thank
linked
you.
to paragraph 182.
Yes, thank you. Which paragraph now?
We are now getting to SB3, Madam Chair, to which I've referred Advocate Patohi.
Page number?
SB3, go to page 153.
You can tell us what the document is.
The document is an internal memorandum by Advocate DCOC and others and his team, which starts on page 134.
Thank you.
Are you on page 153, Advocate Patohi?
I am on page 153.
Maybe before you go to 153, let's
Maybe
go to
152.
first go to 152.
Yes, that's correct.
Under paragraph B, where the panel deals with the legal position in respect of racketeering prosecution.
That's correct.
Read that into the record, and
So,
thereafter
Chairperson,
you can explain whatever you wanted to explain in regard thereto.
so Chairperson, to contextualize, I had been asked about whether there was no evidence, and there was a discussion around no evidence and insufficient evidence. And I wanted to clarify that my evidence that there was no evidence relates to charges to support the charges of racketeering. And I want to explain that now. So if we from page 152, paragraph 63, that's SB3, paragraph 63 first, that part deals with that section in the document is headed legal position in respect of racketeering prosecution. And then the subhead is the nature of the crime of racketeering. Paragraph 63, criminal law targets perpetrator. The crime of racketeering as defined in POCA focuses on the enterprise and objects rather than on the perpetrator. Racketeering is a complex crime which bears some resemblance to the common law crime of conspiracy. It usually involves group activity. In South Africa, for a person to be liable under Section 21E of POCA, he or she must participate or be involved in at least two underlying offenses listed in Schedule 1 of the Act. 65, the offense consists not in the commission of an act such as stealing, but in the membership of an organization which has been shown to have committed at least two particular offenses. The focus is on the relationship between the accused, the enterprise, and the pattern of racketeering activity. And then the next subhead deals with the offense of participating in the affairs of an enterprise, which is Section 21E of the POCA, Prevention of Organized Crime Act. And then the panel sets out in paragraph 66, 67, 68, essentially what this offense entails, that is participating in the affairs of an enterprise. And if we look a little further down, 66, the accused is guilty by virtue of being involved in an enterprise and being involved in the commission of two or more offenses. And 67, they set out factors that would be taken into account to determine a pattern of racketeering activities. And the factors are listed there. I won't list them. In paragraph 69, The panel looks at what the pattern of racketeering activity requires, at least 2 acts of racketeering activity. It has been held in several cases, US cases, that a mere existence of multiple acts of racketeering may not be enough. The criteria are that the acts must amount to or pose a threat of continued criminal activity. Paragraph 17 deals with the elements of this offense of participating in the affairs of an enterprise in terms of Section 21E, and that is set out: an enterprise existed, the accused managed or was employed by or associated with the enterprise, pattern of racketeering activity existed, the accused directly or indirectly conducted or participated in the affairs of the enterprise through a pattern of racketeering activity.
71.
Well, the
Deals
next
with?
subsection is the next offense, and these are the 2 offenses that the authorizations of Advocate Jiba and Advocate Abrams related to. Section 21F is the offense of managing the enterprise in terms of poker, and Section 71 states managing the operation or activities of the enterprise is the offense. Here, the target is the manager. It must be shown that the accused occupies some kind of management position in the enterprise. 72 deals with the elements of this offense of management, and those are set out in that subsection. I won't read it in detail unless I'm required to.
You don't have to.
And yeah,
Yes, is there anything that you want to?
no,
No.
that's just in brief what the these offenses actually entail.
Now, having in mind what you set out in paragraph 182 of your affidavit, when you say, and in my assessment, no evidence against Boyesen, can you explain this concept, no evidence,
Yes,
vis-a-vis racketeering charges?
yes. So that is the position. I concluded that, and looking at the evaluation that was done by the panel, and bearing in mind also that Judge Govan also found that there was no evidence to support racketeering charges. But on the base of the evaluation in this report, which starts at page 157,
In paragraph 77.
77, they state the evaluation of the evidence in the docket will be done in accordance with the principles of the law discussed above, some of which I had just referred to a moment ago. They then proceed in the paragraphs that follow with their evaluation of the evidence.
The next one is paragraph 82, if you go to that one.
At paragraph 82, they state, we also read and analyzed the evidence in the 23 dockets that the prosecution team in their PowerPoint presentation to Abrahams said implicated the accused in racketeering activities. It appears based on analysis of the two, sorry, let me start again. It appears based on an analysis of the 2 indictments that formed part of the documentation Jiba and Abrahams considered that no further dockets were added or removed. Table 3 refers to these dockets. And if we turn the page at 160, Table 3 is the list of the 23 dockets that they considered in this matter.
Now, go to paragraph 83. You don't have to read it, just the content.
Paragraph 83, we will discuss the content of the dockets and in particular some of the challenges in the investigations. In the discussion on the racketeering investigations, reference will also be made to incidents that traversed a period of 4 years from 2008 to 2011. It should be noted that the bulk of the racketeering events occurred between 2008 to 2009, whilst in 2010 there were only 3 events, and in 2011, 2 events. Durban North CAS 67-7 of 2011, CAS 69-7 of 2011, and CAS 71-7 of 2011, referring to 1 moving crime scene. And those CAS are police dockets, those CAS numbers.
Go to SB3, page 228, paragraph 246.
(246), you said?
Paragraph 246, Madam Chair. Are you there,
Yes,
Advocate
I am.
Patohi? Read paragraph 246 into the record.
So just in terms of context, what followed from what I'd read up until this point in the report is an analysis of all the evidence, of the statements of witnesses, etc. And in 246, they state, in respect of both sets of authorizations, a proper case for racketeering was not made out on the papers presented. That is their conclusion.
Are you then able to
Yes, on that, it was on the basis of this.
explain that?
And also on the basis of the judgment of Gorvin, and looking at the evidence that was presented there, that I concluded that there was no evidence to support racketeering charges.
Go to paragraph 274.
Sorry, in the
In
report?
SB 10.
Oh.
What volume is that? What volume is that?
That is one of the annexures to Advocate Patohi's
Thank you.
affidavit,
SB 10.
SB 10.
Are you still on the point of the no evidence? Or in relation to something else?
We're still in the no evidence issue, Madam Chair.
SB 10 page.
Page 274. And the contrast between the Mdluli and matter and the poison matter. Are you there, Advocate Patohi?
I am.
Just describe this document. It is the letter by Advocate Batohi to Minister Lamola, correct?
Yes, it is a ministerial memorandum to Minister Lamola, Minister of Justice and Correctional Services, from Advocate Patohi, which is a request to institute an inquiry in terms of the NPA Act.
Thank you.
Can you read paragraphs 24 and 25 into the record?
Yes, I will certainly, but before that, Chairperson, to answer your question about the no evidence aspect, to be clear, Chairperson, what I'm going to read now speaks to the entire paragraph 182, where I say that Advocate Chauke had vigorously pursued criminal charges against Boyson when there was, as found by the High Court and in my assessment, no evidence against Boyson, but in the Mdluli matter had adopted the opposite stance and declined to prosecute instead of referring the death of the victim, etc. So the point I make, Chairperson, is I'm referring to this part to also addressing that stark contrast in Advocate Chauke's assessment of these two matters. If I may proceed, Chairperson.
Before you proceed, let me look at your paragraph 182. No, understand. And this memorandum to the minister also addresses, part of it addresses this very point.
It deals with the same point, Chairperson.
You may proceed.
Thank you, Chairperson. At paragraph 24, I state that the Cato Manor and Mdluli matters were all part of a much larger complaint of state capture leveled against several prosecutors, including Advocate Chauke, and dealt with before the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state, in brackets the State Capture Commission. Unfortunately, the State Capture Commission was unable to complete its inquiry into the state capture of the NPA. Paragraph 25, the significance of the Cato Manor and Mdluli matters is above all to be found in Advocate Chauke's starkly contrasting actions and his exercise of decision-making powers in dealing with the two matters. A, it is apparent that there was no evidence to support the racketeering charges in the Cato Manor matter, yet Advocate Chauke and the prosecution team seemed to be determined to institute charges against Major General Boyson, and did so with great vigor, committing various breaches of the prosecution code of conduct in their efforts to do so. I should add it should have included the Constitution as well as the NPA Act, prosecution policy and directives. B, this must be contrasted with Advocate Chauke's handling in the Mdluli matter, in which there was a strong case against Lieutenant General Mdluli, yet Advocate Chauke appears to have been at pains to avoid prosecuting him. At 26, it is important to note that these apparently contradictory stances were adopted at approximately the same point in time. It was around this time that the fraud case against Lieutenant General Mdluli was also withdrawn in the NPA. I'll stop there, Counsel.
Now, you have dealt in a nutshell on what you are now stating in your paragraph 183. Paragraph 183 of your affidavit.
Yes, that's correct.
Go to paragraph 184. Of your affidavit.
Just a moment.
Paragraph
184.
Yes, I'm there.
Proceed to read it into the record.
Perhaps I will read 183 as well. I considered Advocate Chauke's versions in relation to the Boyson matter and the Mdluli matter. I've outlined his defenses in respect of both of the matters above. I was satisfied that his version in respect of the Boyson matter was untrue. As explained above, there was ample evidence to suggest that he acted as the de facto DPP of KZN, took prosecutorial decisions, managed and coordinated the investigation process, and that he was intimately involved in the prosecutorial process. At 184, I say, I did not accept this version in respect of the Mdluli matter for the reasons set out above. And 185, sorry, Counsel. 184.
Advocate Mhlaminyane, if I may ask a question, and I'm sorry, I'm going to take you back to paragraph 182, where the witness was supposed to show us that there was no evidence. And I'd like the witness to go back to SB3, page 226. Because that's where I think the team deals with their conclusion. The conclusion starts at 225.
225, Madam
SB3.
Balweme, SB3.
Yes, page 225, but I want us to go to page 226.
226, I'm there.
Yes, and if the witness can read paragraph 239 and explain her understanding of that paragraph.
Are you there, Advocate Batohi?
239.
Yes.
At
Yes, I'm
page
there.
226.
Requested by Madam Balohi Mere that you should read paragraph 239 on page 226. of
239.
SB. Yes, 239.
After a careful evaluation of the evidence contained in the dockets, the pleadings in the various applications brought in this matter, we conclude that there was insufficient evidence placed before the acting NDPP, Advocate Njiba, and NDPP Advocate Abrams to justify the authorizations to institute a prosecution in terms of Section 21E and 21F of the Prevention of Organized Crime Act 121 of 1998. Despite the, sorry, should I continue to 240?
No, just enlighten me what you understand by this, the contents of this paragraph.
Yes. Having
and,
looked,
and in particular in relation to the no evidence principle.
having looked at the report in its entirety, I came to the conclusion that there was no evidence to support the racketeering charges. That doesn't mean that there's no evidence, but there's no evidence to support the racketeering charges. So I think it's important to make that distinction because the dockets contains statements, etc. But whether there's evidence to support racketeering charges is the question. And in that regard, having looked at the entirety of the report, I concluded that there was no evidence to support the racketeering charges. And as the panel puts it, they say there was at 246, in respect of both sets of authorizations, there were a proper case for racketeering was not made out on the papers presented. So that is the way I can explain the way they refer to not sufficient and insufficient evidence, and when compared to whether there was evidence to support racketeering charges.
Advocate Batohi, you read your paragraph 182, and then you referred us to this memorandum and in particular paragraphs to show that there was no evidence.
That is correct.
And to support racketeering charges.
That is correct.
And racketeering charges, if you may assist me, is in terms of Section
21E and 21F.
21F.
That's correct.
That paragraph 239,
Yes,
deals with Sections 21E and 21F.
that is correct, Chairperson.
And it talks about insufficient evidence.
That is correct, Chairperson.
So your submission, your overall submission is that you read this whole memorandum, and after reading it, you came to the conclusion that there was no evidence to support racketeering charges.
That is correct.
Despite the fact that the authors of the memorandum tells you that there is insufficient evidence. They are not saying there is no evidence. They say there is insufficient evidence. And then the paragraph that you just read now, 246, that a proper case for racketeering was not made out on the papers. But this statement, a proper case was not made out on the papers, does not mean there is no evidence.
Chairperson,
Or is that how you understand it? That it means that there is no evidence?
I want to explain why I say that. If you look at the report in its entirety, and I want to highlight a few aspects from the report that will explain why I came to the conclusion that there was no evidence. And I would submit that the panel, in fact, also came to the same conclusion. Firstly, Advocate Sean Abrams, when he took office, he was not prepared to sign the POCA certificates, understanding that Advocate Jiba had already signed authorizations, I think in 2014. Advocate Abrams was not prepared to sign the authorization, and he wanted additional information. He wanted additional investigations. It was in 2015 that he was presented with a new memorandum. At this stage, he was still not satisfied. He then sent 2 staff members, Maema and another colleague, to Greece to get the statement of Danikas. When they returned, he said, and this is looking at his statement, I think he made before the Zondo Commission, but that is also an attachment to the de Kock report. Advocate Abrams' statement is attached. He says that when they returned, there was now considerable material before him when he issued the authorizations that did not serve before Advocate Jiba. The panel concluded at page 103 of the de Kock report that these were the statements and factors that he considered as the basis for the decision to authorize the racketeering prosecutions. And that's important. And they are the statements of that we've dealt with some of them. Colonel Ayer's further statements. He also referred to the ex-provincial Deputy Commissioner Brown's statement. He refers to the Danica statement, the statements of Mtiane, Matonzi, and Mkiz. And after studying, this is what he calls new evidence. Sorry, let me rephrase that. After studying the new evidence, according to Advocate Abrams, the panel concluded as follows. Firstly, the statements of Ayer and Brown were unable to assist the prosecution in proving that Boyson managed a criminal enterprise and or participated.
Sorry, where are you?
I've pulled out from the report, and I've just got some notes that I'm reading through at the moment to show that there was no evidence.
Which report? The one that is in front of us?
The de Kock report, that's correct.
You're now reading the conclusion.
No, I've taken out of the report some aspects to show why I concluded that there was no evidence. And I'm going through that, but it's from the report, but I've pulled them out and made separate notes, which I am going through now.
Through you, Madam Chair, maybe to assist the witness and Madam Baloyi Mere to answer the question and to get that maybe the required answer. Reference can be made to paragraph 190 whilst dealing with this issue of no evidence, insufficient evidence, and sufficient evidence. It might well be 190 of the internal memorandum of Advocate de Kock and others. Page 201, SB3. SB3, Madam Chair, annexure SB3 to Advocate Batohi's affidavit on page 201, specifically in paragraph 190. If you may read that paragraph 190.
Yes, thank you, Counsel.
190.1 and 190.2, that may assist you in answering the question.
Yes, thanks for referring me to this part. The heading of this section is concluding remarks on the racketeering offenses. 190, it is clear from our discussion that the prosecution will not succeed in proving the racketeering offenses for the following reasons. 190.1, there is no evidence to establish the existence of an unlawful enterprise separately from the existence of a pattern of racketeering activity. 190.2, the prosecution simply had several cases that they alleged established a pattern of racketeering activity and then attempted to show through the statements of Ayer, Danikas, Matonzi, Mkize, and Ndlolo that an enterprise existed. the case law is clear that an enterprise cannot simply be the undertaking of acts of racketeering. A racketeering indictment should focus on the entire enterprise rather than individual participants in specific acts. Should I read the entire 190?
No, it's enough up to there. I intercepted Madam Baloi Mere with his questioning. She can then proceed.
Thank you.
But I just wanted you to have this in front of you when you are answering the question.
Thank you, Counsel. And
What is therefore relevant is 190, 190.1, and 190.2.
That's correct, Madam Chair. For current purposes.
I think perhaps if we look at 190.3, the statements do not, I think that no means should be not, prove that an organized criminal group existed that acted in common purpose and conspired together on a continuous basis to commit murder. I think given that the chairpersons asked specifically, I think if one looks at the rest of 190, I think it's also relevant for these purposes. And Counsel, maybe I should just quickly go through those as well. If
I think the witness should, because I'm looking at 190.6.
Mhm.
So maybe it's better to read
Sure.
all those sub paragraphs of 190.
Certainly.
Up to
190.4.
190.6.
190.4, the statements do not prove that each of the managers in the criminal enterprise played a defined role in its operations and pursued their common goal to commit murders for profit on an ongoing basis as a cohesive unit. By simply choosing the managers of the enterprise according to the organizational structure of the South African police and the positions they held within their own units and/or sections, the fallacy of this approach was exposed. Despite Mostad's alleged managerial role, the prosecution could not charge him since he was not a manager in the police. If one has reference to the evidence as contained in the, 190.6. If one has reference to the evidence as contained in the dockets, the alleged enterprise was on the verge of extinction. In 2011, the accused are only charged with 2 racketeering acts as compared with the 9 racketeering acts in 2008. To show a continuity, the racketeering acts must include a specific threat of repetition extending indefinitely into the future.
So from this report, we are now told that it is clear from the evidence contained in the dockets that the alleged enterprise was on the verge of extinction.
What they are referring to there, they say alleged enterprise.
Yes.
And the enterprise that they are referring to would be the Serious and Violent Crime Unit of the police. And perhaps that was closed shortly thereafter. I can't remember. I can't recall. But that's what they're referring to.
I'm sorry, I didn't get that. You said the alleged enterprise would be?
The Serious and Violent Crime Unit of the police.
How do I differentiate between, because this is concluding remarks on the racketeering offenses,
Mhm.
and it talks about an enterprise, but I don't see anywhere where it specifically refers to the unit that you referred to.
It is in the report, and as I've said, the entire report is in evidence. I'm just dealing with some aspects of it. If I can be guided, there is a section in this report that talks about the enterprise.
But before you even go further, let's read the 190.6 in its entirety. You can read it again.
If one has reference to the evidence contained in the dockets, the alleged enterprise was on the verge of extinction. In 2011, the accused are only charged with 2 racketeering acts as compared with 9 racketeering acts in 2008. To show a continuity, the racketeering acts must include a specific threat of repetition extending indefinitely into the future.
So that cannot possibly refer to the unit that you are referring to. It could possibly refer to the alleged racketeering enterprise, which evidence shows that in 2008 there were how many charges? 9, and then in 2011 there's only 2. Because if it were to mean the unit that you are referring to, then it would mean that you are actually charging the unit. But we are now here talking about racketeering charges, which we are told have gone. The charges have now reduced from 9 in 2008 to 2 in 2011. Not unless I don't understand this paragraph.
Yes, with all due respect, I think I need to explain the aspect of an enterprise in a racketeering charge. And that is dealt with in this report. Because you can have, in terms of the Act, an enterprise can be defined as an existing formal structure, which is, for example, a unit in the police. Or the enterprise can be an association of individuals, in fact, a more informal structure. So what it was is dealt with in what the enterprise, how the enterprise was considered in this matter is dealt with. I'm not sure where it is, but there is definitely a section in this report that speaks to this very issue about how to define the enterprise. And this is an important aspect of racketeering.
Would it not be helpful to go to the definitions of the Act, rather?
Yes, it certainly will. But it certainly will, Chairperson. We can do that. We have POCA, but in terms of how the enterprise was understood in this case, just to answer Madame Baloy-Mera's question about it being a unit in the police, it will be important to go to the report. But generally, in terms of defining the enterprise, we can go to the Prevention of Organized Crime Act, which I have somewhere. It was under. Oh, and maybe
when you look at 2.1.
If you bear with me, Chairperson. Thank you. Okay.
Yes, I was saying of relevance for this question could be the definition of enterprise. And you could also have regard to section 2 that deals with offenses. And then 2.1e and F, in which reference is made of managing, relevant to the Katomena issues,
That's correct,
to
Chairperson.
managing association with an enterprise or conducts or participate in the conduct directly or indirectly of such enterprise affairs through a pattern of racketeering activity. F, manages the operation within the context of the group or activities of an enterprise. And who knows or ought reasonably to have known that any person while employed or by association with the enterprise conducts or participates in the conduct.
Yes, Chairperson. If I may go to the definitions of enterprise first in section 1 of the Act.
Yes, ma'am.
Enterprise includes any individual, partnership, corporation, association, or other juristic person or legal entity, and any union or group of individuals associated in fact, although not a juristic person or legal entity. So the point being, you could have a formal structure or you could have an informal structure. And in this case, this aspect was dealt with. And I just want to try to find, I think it's the paragraph that deals with the enterprise. Did we get? 152. I think it's page 152. Paragraph 152. I think it's paragraph 152. I beg your pardon.
Your affidavit.
No, it's of the report SB3. I'm just looking at that to make sure that I've got the right reference.
154 deals with the 23 dockets. Is that the one you're looking for?
No, not 154. No, Chairperson, I see at 152, it does, paragraph 152 at page 185. It does deal with the enterprise and its characteristics. It goes into the act which we had dealt with. If I could just read that carefully.
What paragraph is that, Council?
I beg your pardon, Chairperson.
What paragraph is that?
Paragraph 152.
SB3.
Yes, SB3, page 185. I'm just reading, Chairperson, to make sure that it is the paragraph I'm looking for. Here it's more general. Look for. I don't think that's this paragraph I'm looking specifically for, Chairperson. My apologies, but I'm
Yeah.
trying.
Advocate Patohi, 152 deals with an enterprise. Is that not the one that you're looking for?
Yes, it deals with the characteristics of the enterprise, but I was looking for a particular paragraph where the team was considering whether the enterprise being the serious and violent crime unit of the police.
Okay, maybe that what will help is maybe we should start at 70, paragraph 70, and then go to the organogram of the entity, Katomana unit, which is dealt with.
Okay, Muthamnyane, we have veered from my question. Can I bring us all back to my question?
My apologies, sir.
I wanted clarity on paragraph 190. Was it 190.6 on no evidence? Now we are bringing in a lot of things, but I want us to go back to SB3 page 135 and look at the purpose of this memorandum. If the witness doesn't mind reading the purpose at SB3 page 135 into the record.
If you bear with me for a moment. SP3, page
135.
The purpose of this memorandum is to provide the NDPP with an opinion as to the validity and the appropriateness of the decisions by the former National Director of Public Prosecutions, Advocate S. Abrams, and the acting National Director of Public Prosecutions, Advocate N. Jiba, to authorize a prosecution in terms of Section 2.4 of POCA Redwood, Section 2.1e and 2.1f in respect of the state versus Boyson and others.
That was the purpose of this memorandum.
Mhm.
Now, what they say at at paragraph 190.6, and I wanted to okay, I wanted to right. I wanted you to look at it at paragraph 190.6 and paragraph 239, because when you started dealing with this document, you said you are clarifying the no evidence issue.
Mhm.
And when I went to paragraph 239,
Mhm.
you then said, okay, they said there is insufficient evidence,
Mhm.
but upon reading the whole
Mhm.
memorandum, you came to the conclusion that there was no evidence
To support racketeering charges.
to support racketeering charges. And when the whole memorandum was on racketeering charges, on the authorization on racketeering charges by both Advocates Jiba and Advocate Abrahams.
That was the purpose of the memorandum.
That was the purpose of the memorandum.
Correct.
And nothing else. Now, paragraph 239 tells us that there was insufficient evidence to support the authorization in terms of 21E and 21F.
Mhm.
And then you then read 246, which says, in respect of both sets of authorization, a proper case for racketeering was not made out.
Mhm.
And it was when I asked this question that does not, if papers are submitted, but they do not make out a case to support or to result into a positive order given.
Mhm.
Does that mean that there was no evidence at all? And then we went to then 190.6, which then spoke about an enterprise that was an alleged enterprise that was on the verge of extinction. And then that's where you said the enterprise might not mean the racketeering issue. It might mean, what did you call the cattleman? You called it
The SVC. Serious and violent
serious
crime
and
unit.
violent crimes. And that's when we started talking about the enterprise. And when we the proper reading of the definition of enterprise, and also when you look at the purpose, the purpose was not to investigate the SVC, serious and violent crimes. It was to investigate whether there was a reason to issue authorization certificates for racketeering. So, can I conclude by saying, can we agree that after reading this, you came to your own conclusion that there was no evidence, despite the fact that in some instances, the authors of the memorandum tells you that there was insufficient evidence, and we know what insufficient evidence means.
Okay. So I can't agree with your last question, and I've got to explain why. Firstly, There are several comments that you made in the course of getting to the question that I need to comment on. For example, the purpose was not to investigate the SVC, but to investigate racketeering authorizations. Now, the whole point here is that my understanding is what the team was saying is that the SVC is the enterprise. That is what I was trying to find, that part in this report that actually talks about how the enterprise is defined, how the team was attempting to define the enterprise. So this is a very technical, highly technical issue, and it's important that I be permitted to explain. And I've been taken on tangents. I was actually trying to explain the evidence, no evidence, and I had this document that I'd selected parts from this report, and I was trying to go through that to show that my conclusion that there was no evidence was based on those things. And then I got like a third of the way, and then we went to the Act, we got to enterprise, and I'm trying to answer the questions, but we do get sidetracked. But now I'm coming back to your question, which has a lot to it. So I need to explain a few things. Firstly, I'm hoping that paragraph 149, which my colleague says to me might help, is what the paragraph that I'm looking for, that will clarify the issue of SVC and the enterprise.
Paragraph.
149, but I'm checking myself to make sure it's the correct one. No. No, I don't think that's the paragraph I'm looking for. Chairperson, the point I was trying to make, and maybe I'll find it later in this document, is that the team, in order to prove racketeering, you have to prove that there was an enterprise. An enterprise can be a formal structure, like a unit of the police with a formal command structure. Or an enterprise could be a more informal structure where there are individuals that are, as the Act states, associated in fact. But it's a more of an informal arrangement, but it's nevertheless has a kind of structure where you have a manager and you have others that participate and play different roles in the enterprise. In this case, my understanding is that the team that were proposing racketeering charges were actually defining the enterprise as the serious and violent crime unit, a formal structure in the police. And that is the relevance of that unit to the charges relating to racketeering. So I'm just trying to think how to structure my response. 152.1, let me check 152.1, Chairperson, if you'll bear with me. I'm checking 152.1. So 152 and it states, an enterprise is characterized by its members having a common or shared purpose, where there is some sort of hierarchical decision-making structure and where the enterprise is ongoing with some continuity of personnel. The Prevention of Organized Crime Act 121 of 1998 does not define who is a manager. 152.1, in respect of who the managers of the enterprise were, the prosecution charged the accused according to the organizational structure of the South African police and positions they held within their own units and or sections. Boyson was charged as a manager, since he was the provincial commander, organized crime KZN, and later on the provincial head, DPCI KZN from 2010 onwards. Olivier was the section commander of the section, while Lockham and Van Tonder were group commanders in this section, whilst all the others under their command were charged in section 21E. So that is why I was talking about the SVC being the enterprise that the team was saying was the racketeering enterprise. I think 152.1 actually does address that. I'm just looking at the other paragraphs that follow.
Advocate Batohi, I'm sorry to interrupt you. I don't think you and I are at loggerheads with what you are saying.
Sure.
I think we agree.
Mhm.
We agree about an enterprise, not and we agree that what you've just read, that Boysens was charged, he was deemed to be the manager of the enterprise because of the position that he held. That I'm paraphrasing, but I hope I'm correct. I'm quoting you correctly. And the other person, Olifir, was considered to be a manager because of whatever position he had. So that doesn't differ from what I'm saying. All I'm saying is the purpose of this memorandum was to deal with the enterprise and was to deal with the authorization certificates by both Advocate Jiba and Advocate Abrams. And somewhere in this memorandum, they say they mischaracterized the two police officers as managers of an enterprise, and also they approached the two heads of NPA with insufficient evidence while seeking authorization certificates for racketeering. Should I repeat the last portion?
No, I heard it.
Yes. So I'm saying you and I think we are on the same page, except only that you, after reading this whole memorandum, you came to a conclusion that there was no evidence at all. I will leave it at that.
No, I'm considering my response to that.
Oh, okay.
No, sorry, my apologies. I'm just reading your question before that because I want to make sure that I respond correctly. So I'm reading about your comments that you say they mischaracterize them as managers. Are you referring to the authors of the report that mischaracterize them?
The authors say the applicants for the authorization of the racketeering certificates, and that's the paragraph that you just read. I think 152.1. Because they say they charge the accused according to the organizational structure of the South African police. I'm saying maybe they mischaracterize. They read or they assumed that they are managers of the enterprise based on the positions that they held within SAPS.
So maybe so it's not the authors. Sorry,
Not the
that's fine.
authors,
Okay, but it's the team.
Applicants,
Understood.
the team, yes.
Understood. Chairperson, yes, we can only surmise about what they thought when they looked at the evidence. So I can't comment on that. But what I do want to say is that I was trying to answer the question at the outset about why I came to the conclusion, correctly as you say, having read all of this, having read the report, considered the evidence, as well as the Govan judgment, that there was no evidence to support racketeering charges. And I do want to state specifically that in that regard, we have a situation where we have the key statements that both Advocate Jiba and Advocate Abrams say they relied on to come to the conclusion that they could authorize racketeering were statements that we've dealt with. And in terms of dealing with the additional statements that Advocate Abrams said he got, the statements of Ayer and Brown were not able to assist the prosecution in proving that Boyson had managed a criminal enterprise or that he participated in the affairs of the criminal enterprise, which Advocate Abrams had actually took those statements to prove that. Well, maybe with other things as well. But the Danikas evidence, this was unsworn statement. And I do want to refer to our policy directives that deal with whether, and I was asked a question some time ago about whether information or evidence that's not sworn can be considered. And I want to specifically refer to our policy directives. I think it is that deals specifically with this aspect.
Yes, Advocate Batohi, they are not part of the record. We will then ask that they be handed up as exhibits.
Thank you.
Madam Chair, with your permission, the policy directives are not in the bundles. It's only the code of conduct and the prosecutorial. They have the policy directives. And they will later be marked as exhibits accordingly. And I'm giving my colleague 2 copies.
It's a policy itself.
This is part of the policy directives.
Where's the policy?
This is a part of the policy directive that runs from part 4. Is it deliberate that you're giving us only these pages?
I had to look in this week.
It is deliberate. These are the pages that those copies I have, which have been given to me by the NPA team.
Will we have a complete document at least? How big is this document? I've read somewhere Pardon?
Please can you find that one?
I've read somewhere where they refer to certain portions of policy directives, but I'm not sure whether that is confined only to part 4. Otherwise, we'll have a piecemeal referral to this document, and it may end up being marked differently at a later stage.
Madam Chair, I'm informed by the NPA team that yes, it is deliberate, but the witness will explain why it is as it is now.
And this document is in relation to which point, which my sister was asking? Is it connected to those issues that have been raised regarding the no evidence?
It is connected, Madam Chair.
It is connected.
Yes, it is connected, as well as the withdrawal by prosecutors, institution of prosecutions. It deals with that.
Yes, I just want to make some.
Advocate Batohi.
Yes, my apologies, Chairperson. I'm trying to find the document. Firstly, I should perhaps deal with the policy directives that we've handed in. Chairperson, the policy directives are confidential, is a confidential document. It's not made public. And this document, so what we've done is we have, I have obtained permission from the Executive Committee of the NPA to disclose these parts of the policy directives. I think it's about a 150-page document that relates to specific aspects that have been canvassed in this inquiry, and that is part 4 that deals with institution of prosecutions, Part 5 that deals with withdrawal of cases and stopping of prosecutions, and Part 6 that deals with representations and reasons for decisions. Chairperson, but I am looking specifically to go back to where we were. I was dealing with the fact that there was no evidence, and I said that the issue of sworn statements, there is in one of our directives or the policy itself very clear direction that it is only sworn statements that must be considered as evidence before a decision to prosecute is taken. I'm going to find that, and we will then refer the panel to where exactly that can be found.
Madam Chair, I'm alerted to the fact that it is lunch break.
It is a lunch break, and I must check first with my sister whether she is done with her questions.
I am done, but I wanted to ask Advocate Batohi to consider something while on lunch. Can you you keep on referring to, is it Danika's statement that was not deposed to? Can you look at it and also read Section 2 of the Poker Act, subsection 2, and advise us on how that is dealt with and whether your policy directives can trump what is contained in the Poker Act in Section 2, sub 2.
Certainly can't trump an act, but I'll have a look at it and see how it
Please.
works
Thank
together,
you.
perhaps.
Chair, thank you.
We adjourn in relation to this aspect of the no evidence. I'd like you to look at paragraph 143, SB3 183 at paragraph 143, and clarify what we should make of this statement.
Chairperson, if I've got that right, SB3,
SB3 183 at
Is that-
paragraph 143.
page 183 at paragraph 1.
143. The admission made by General Boyson of his presence at the scenes. And I'm raising it in relation to the no evidence as regards the racketeering charges.
Certainly,
So
Chairperson.
you can
Chairperson,
reflect on that, and you may address us when we reconvene.
sure, we have found the policy, but I'll deal with it after lunch.
Yes, thank you. Let's take a lunch adjournment. It's now 10 to 2. Maybe we do 10 to 3. I've conferred with my sisters. We'll have an hour lunch break until 10 to 3. We adjourn. Good afternoon, everyone. Afternoon, Advocate Batoyi. Good afternoon, Dr. Chauke. Afternoon, Advocate Mutlamoyani. You may proceed. You are still under oath, madam.
Yes, thank you, Chairperson.
Thank you, Madam Chair.
When we adjourned, I drew your attention to paragraph 143 of SB 3183. In relation to the issue of no evidence, what should we make of the statement? The admission by General Boysons, among other things. Insofar
Advocate Batohi, you may perhaps want to read that paragraph within
Yes.
its context to enable you to answer,
Sure.
to
Thank
give
you.
an appropriate answer.
I'll do that. Madame Baloy-Mayer also asked me a question before that. I'll deal with that after this question. So at 143, Boyson admits in his applications that he was on another crime scene, which is further corroborated by an entry in the occurrence register dated 4 July 2011 by Captain Msomi. In fact, both Captain Olafia and General Boyson, who it is alleged managed the activities of the SVC section of the Durban organized crime, were present afterwards at the crime scenes in Durban North CAS 67 of 7, 2011, 69 of 7, 2011, and CAS 71 of 7, 2011. So the question is, what do we make in relation to this issue when one considers the evidence, no evidence issue, particularly in relation to racketeering? So, Chairperson, what this statement says is that Boyson admitted that he was on another crime scene. And in terms of racketeering, one has to prove that you committed 2 predicate offenses. Now, one has to read more of this report to understand whether there's any suggestion that this was one of the predicate offenses. My understanding is that it isn't, because if I'm not mistaken, this particular scene relates to the Howick scene. I hope I'm not mistaken. And no, I'm not sure that it can be Howick, because it's Durban North CAS 67. So it definitely cannot be the Howick matter. But the point being that they are police officers and they will be attending crime scenes. That is what part of their job is. And in this particular instance, they are admitting that they were at a particular crime scene. But the panel that looked at this found that even though there was evidence that Boyson was at a crime scene, in the one instance in the Howick matter, where he arrived after the incident, there was no evidence to prove 2 predicate offenses in respect of General Boyson, which is one of the requirements one of the elements of the requirement, the racketeering offense. And even if you are on the scene with regard to predicate offenses, you have to have evidence that the person was actually involved in the commission of that offense. So even arriving on the scene later would not have been sufficient. So the short answer, Chairperson, is that it would not still prove that there were 2 predicate offenses that Boyson had committed within the specified period in order to satisfy one of the elements of racketeering.
in the context of 21E and F, will your answer still be the same?
Yes, Chairperson. 21E and F relates to the management or the participation in the enterprise. And that is correct, Chairperson.
Where does management, E speaks of management, and where does participation appear there? Beg your pardon?
One of them is
In
management.
E, speaks of managing or employed by or associated with any enterprise.
Mhm.
Conducts or participate in the conduct directly or indirectly.
Mhm.
Now my question is in relation to 21E, will your answer, given the phrasing of 21E, will your answer still be the same?
Chairperson, it will still be the same
Thank
because
you. If it is still the same, I'll accept that. for
yes,
now.
I will just explain why in one sentence, because you still have to prove two predicate offenses. Once you establish two predicate offenses, then you can then look at what the role of the person was in the enterprise.
Where in 2.1 do we see the need to establish a predicate offense?
Okay.
Because 2 speaks of 1 and sub A, B, C, D, E, F.
I'll find the
Where does it require
Section.
that one would have had to establish a predicate offense?
two predicate offenses, yes. What section is it? You'll find it. Chairperson, I have to find the section in POCA that requires, I think it might be in the definition, I'm not sure.
Because
It might be in the definition.
my reading of section 2 is a standalone provision that refers to offenses.
Maybe go to Advocate Batohi, with your permission, Madam
Definitions,
Chair, to the definition of pattern of racketeering activity,
Yes,
section 1 of the
That's
definitions.
right, I'm there. Chairperson, one of the requirements, one of the elements of racketeering is a pattern of racketeering activity, and it's defined. It means a planned, ongoing, continuous, or repeated participation or involvement in any offense referred to in Schedule 1, and includes at least two offenses referred to in Schedule 1, one of which one of the offenses occurred after the commencement of this Act, and the last occurrence occurred within 10 years, excluding any period of imprisonment, after the commission of such prior offense referred to in Schedule 1. So one of the elements is a pattern of racketeering activity, and this is what needs to be established.
Thank you.
Thank you, Chairperson.
Thank you.
If I may proceed to the question that was raised by Madame Baloy Mera before the lunch break. The question was that I keep referring to Danika's statement that was not deposed to. I hope I get this right. I'm just making sure that it is. To read that with section 2.2 and advise in the context of section 2.2. Firstly, let me deal precisely with that. With section 2.2 of the POCA, reads as follows. The court may hear evidence, including evidence with regard to hearsay, similar facts, or previous convictions relating to offences contemplated in subsection 1, notwithstanding that such evidence might otherwise be inadmissible, provided that such evidence would not render a trial unfair. Chairperson, in order to answer this question, we have to first go to, well, let's first deal with it in this way. Danika's statement is not, my understanding is that it is not presented as hearsay evidence in this matter. Hearsay evidence, as we all know as lawyers, is where a person mentions something in a statement that somebody else told them. But even that person who makes that hearsay statement must depose to that in a sworn statement, in a signed sworn statement, before it can be considered to be hearsay, before it can be considered to be evidence at all. And in this regard, I want to refer us to part 4 of our policy directives. A states criteria, section A criteria, paragraph 1. A case, may I proceed, Chairperson? Thank you. A case may only be placed on the roll if there is evidence under oath or affirmation that establishes the elements of an offense and links the identified suspect to it. This applies equally when the docket is presented to the prosecutor as a so-called decision docket without any arrest, or when the docket is presented following the arrest of an accused person. So it is simply not acceptable, it is not permissible for a prosecutor to consider a statement that is not sworn as evidence at any stage. So that is my response to that question.
Thank you, Advocate Batu.
Thank you, Chairperson. I think those were the two questions before the lunch adjournment.
Mayane, please proceed.
Thank you, Madam Chair.
Suppose you are going back to the statement to Advocate Batoi's affidavit.
Yes, we'll go back to it in a moment. Whilst you're still on the directives, let's go to page 14. That is part 5 thereof, where it deals with withdrawal of cases and stopping of prosecutions. Read the whole.
Just bear with me, Chairperson. I'm looking for another document. I think it's this one. Or this one, yeah. Yes, thank you, Chairperson.
Do you have it in front of you?
I do.
And by the way, this policy was updated in April 2012, not so?
Yes,
policy
that's
directives.
correct. This is the one that's dated 2012, April. There was a previous one, I think, from 2006 that was up until 2012 April, and this one was from 2012 April. This is updated here.
Okay. Read.
I will read paragraph 1.
Council, in relation to which aspect are you referring us to this part 5? Because you have been referring us to bundle of documents, and sometimes I don't follow why you go there. It will assist us for preparation so that we can read those documents within a particular context. Sometimes you are referred to a document, you cannot even figure out where you are going.
Reference, Madam Chair, thanks, is to the issue that was dealt with where prosecutors can withdraw charges.
Yes,
To what
thank you.
extent can a prosecutor provisionally withdraw a charge or otherwise withdraw it permanently? It deals with that.
I think the heading speaks for itself, but it means you're going back and forth to issues. So I'm paging backward because I see the heading withdrawal of cases and stopping of prosecutions, meaning that we are revisiting that very issue again. Please
But-
direct us to where you're going to every time you refer us to a document.
Indeed, I'll do so. Advocate Patohi, would you read part 5 into the record?
Yes, thank you. If
Paragraphs 1 to 8 to 9.
I will certainly do that. To contextualize for the chairperson, paragraph 182 that I was dealing with dealt with the issue of the different approaches that Advocate Chauke took in the Boyson matter, where there was no evidence on racketeering to support racketeering charges, and in the Boyson matter that was in the Mdluli matter that was withdrawn. This part deals with withdrawal of cases. Part 5 of the policy directives, paragraph 1, states the following. Once enrolled, cases may only be withdrawn on compelling grounds. Example, if it appears after a thorough police investigation, there is no longer any reasonable prospect of a successful prosecution. I will read paragraph 2 as well. Cases should not be withdrawn solely on the ground that the accused person has compensated or reimbursed the complainant, or on the ground that a complainant requests a discontinuance of the prosecution. Prosecutors should exercise special care when approached by a victim who is in close relationship with the accused person. I don't think that part, section 2, really applies in this matter, but it's fine that I've read it in. Paragraph 3. Wherever a case is withdrawn, the reason for the withdrawal must be provided to the court and noted in the investigating diary. Where necessary, direction must be given in the investigating diary for the further handling of the matter. The prosecutor must sign and date such entry in his name or her name must also be clearly printed. Chairperson, if we go back to the issue of the withdrawal and just in dealing with section 182 of my affidavit, paragraph 182 of my affidavit. I apologize, Chairperson, it gets rather tiring here. Your brain starts freezing sometimes. Paragraph 182 of my affidavit. Looking at, again, the decision of Advocate Chauke to withdraw the charges at the time that he did, there were various reasons why I had indicated that decision was incorrectly taken at that point. And the first one is the strength of the murder and the attempted murder charges. As I had said, they were intricately entwined with the other charges. And the fact that Advocate Chauke himself recognized this. Also, we must bear in mind, Chairperson, that these findings were confirmed in the subsequent criminal trial on the other charges. Another reason why you would not expect a prosecutor in the position of Advocate Chauke not to withdraw these charges in the face of the strength of the circumstantial evidence was the following: the fact that we must not forget, Chairperson, that the murder had taken place about 12 years before that. And in the case that followed later, when General Mdluli was finally charged and prosecuted for the other charges, but not the murder and attempted murder charges, he was also charged. One of the charges that he faced was defeating the ends of justice between 1997 and 2000. And this is one of the charges that he would have faced prior to the murder charges being withdrawn. That's my understanding. And if one looks at that aspect of it, the fact that General Mdluli, my understanding is Advocate Chauke on his own version says that even though he had doubts about the murder and the attempted murder charges, he felt differently. He felt that there was sufficient evidence with regard to all the other charges. And one of those other charges related to defeating the ends of justice. And the allegations in respect of this charge, defeating the ends of justice, was that General Mdluli had actively suppressed the murder and related charges against himself and his co-accused. Missing dockets, it was alleged, were found in his office. If he genuinely believed that this case was strong, then it would mean that he believed that the state would be able to prove that Mdluli, being the accused in the murder and attempted murder, had actively tried to stop the investigation and prevent his criminal prosecution. With respect, any person, particularly in the position of General Mdluli, who tries to do that, that's indicative of a guilty mind, where when you do not want to face, you suppress an investigation. So these are all, this is the wealth, this is what Advocate Chauke found before him. And then we state in our part 5, well, the NPA, that a case, once enrolled, a case must be withdrawn only on compelling grounds.
You are basing this statement on conjecture, isn't it?
Which statement?
The fact that he did all these things because of the way you put it, of a guilty mind?
Chairperson, I'm concluding that a person who does all those things is indicative of someone that wants to hide someone. Let's put it that way.
I'm using the term you used, that you have had a guilty mind. What does that mean? That he is presumed to be guilty even at that stage?
I would say that he had something to hide, Chairperson, at that stage.
Is that what you mean?
That is what I meant.
Because
you
are presumed innocent.
Absolutely.
Until you are found guilty.
That is correct.
That's why I'm raising this point.
That's correct, Chairperson.
That when you speak of the concept of somebody having a guilty mind, it may presuppose that you are prejudging this person, even before the person is tried.
No, Chairperson, that's not what I intended. If I could explain,
No, but you use the concept that he has a guilty mind. That's why I try to check with you. What do you mean?
Sure.
You may proceed.
Thank
Madam.
you, Chairperson. So the point I was trying to make is that, sorry, I'm not sure where I was, what I was talking about.
Advocate Batohi, let me remind you.
Thank you. I'm not taking notes as I speak. That's helpful.
You said once you went back, you gave all your facts, and then you went back to part 5.
Thank you.
And you said once enrolled cases may only be withdrawn on compelling grounds. I can assure you, I had vowed to myself that I'm not going to ask you any more questions, but indulge me with this one only.
Can I refuse that, Chairperson?
You would have to seek my permission.
That's why I asked you, Chairperson.
There are examples given on one. For example, if it appears after thorough police investigation that there is no longer any reasonable prospect of a successful prosecution. But I take it this is not exhaustive. This is not the only reason.
Absolutely, Chairperson.
And then I'll take you back to the first sentence that says compelling grounds.
Mm-hmm.
And from what we've heard so far, even from you, Advocate Chauke withdrew the charges against Ndluli in order to avoid, withdrew, referred to an inquest, but his reason being, I want to avoid a fragmented prosecution. Wouldn't that fall within a compelling ground?
Chairperson, the issue of avoiding a fragmented trial came much later. That decision was made after the, let me get this right. He withdrew the charges of the murder, and then after the inquest findings were made, he was planning to proceed on the other charges and not the murder charge. And that was when he had indicated, Zeisva, I'm trying to just get my thoughts correct. Sorry for going long because I want to answer the question properly, because there's two aspects to it. His withdrawal of the charges initially had nothing to do with fragmentation of the charges. Yes, let me stick to that. So that was not an issue at that point, fragmentation of charges, the withdrawal of the charges. The reason for the withdrawal of the charges, my understanding, is because of the representations that General Ndluli submitted, alleging a rather far-fetched conspiracy. And that was the reason for my understanding, for Advocate Chauke's decision to withdraw and refer the matter for an inquest.
Proceed, Counsel.
You were on the policy
Yes.
directives, part 5.
Yes, I'm not sure if there's any other parts to this that I need to read into the record for current, that will be relevant for current purposes.
Paragraph 8 will be relevant about the stopping of a
The
prosecution.
stopping of a prosecution in terms of Section 6B of the Criminal Procedure Act effectively means that the prosecuting authority is abandoning the case. The accused person will be entitled to an acquittal and may not be charged again on the same facts. A prosecutor may therefore not stop a prosecution without a DPP's authorization.
Go to paragraph 9.
As a rule, criminal proceedings should only be stopped.
I'm sorry. Like my sister, I was not going to ask any question, but I need clarity. So I give myself permission. Paragraph 8, Advocate Mutlamunyani, it does not apply here because it speaks of the prosecutor. Is it relevant here?
Madam Chair,
Prosecution.
yeah, Madam Chair, it is relevant in the sense that a prosecutor himself, an ordinary prosecutor who prosecutes in a magistrate's court, does not have authority to stop a prosecution. He or she can only do so if he or she is authorized by a higher authority, in this case, a DPP. And they can only do that if an accused person has already pleaded. So
My
it is
question-
relevant in that regard.
Yes, but we
Yes.
are not dealing with the prosecutor here. We're dealing with the DPP on the answer of Advocate Batoi. That's why I'm asking, is 6B of the CPA relevant
It is,
for this purpose?
it is relevant, Madam Chair, because a prosecutor is defined in the Act. It also includes DPPs. They are prosecutors, although they are called Directors of Public Prosecutions, but
Yes, that's
in
what-
essence, they are prosecutors.
That's what I thought, but the answer which we from
The Act
Advocate
defines prosecutors. And
from Advocate Batoi a few days ago, she seeks to differentiate, and correct me if I'm wrong. She seeks to differentiate prosecutors with DPPs. And then because here we are confronted with a situation where a DPP is alleged to have misconducted himself, are we now within the zone of Section 6B
No.
of the Criminal Procedure Act relating to the prosecutors, be it in the High Court or in the Magistrate Court?
It may be in the High Court or Magistrates Court, Madam Chair. But my understanding of the
Let me
definition.
find out from the witness. Don't
Yes,
testify.
thank you,
I
Chairperson.
think she can clarify that for me,
Yes, thank you,
because I
Chairperson.
may be misunderstanding.
No, Chairperson, you are perfectly correct. The Act defines a prosecutor as different from a DPP. And that is, I think, your question that you asked.
Yes, thank you. That's why I'm asking. You need not shake your head, counsel. The witness is speaking, and we will only be guided by her testimony and not what you think. So that's why I thought, don't testify from the bar, let her explain to me my misunderstanding. And she says that's how she understands it. My question then is paragraph 8 of the policy relevant for our purpose? Well, if you still believe it is relevant, I thought it isn't, you may proceed.
May I answer that question?
Just before he takes over or continues, I'd like to ask just this one question. The definition of prosecutors, does it include directors?
Let's look at the Act. I
In
don't
the
think it does.
context of the Act, yeah.
Don't think it does. Prosecutor means a prosecutor referred to in section 16(1), and then if we go to section 16(1), 16(1), and then if we go to 16(1), appointment of prosecutors. Prosecutors shall be appointed on the recommendation of a national director or a member of the prosecuting authority designated for that purpose by the national director and subject to the laws governing the public service. And then it states they may be appointed to the office of the NDPP, the office of the 6-1 director, investigating directorates, lower courts. DPPs are appointed by the president.
So the answer is that it does not include.
That's correct.
Directors of public prosecution.
That's correct.
Thank you.
Chair, and I promise I'll be brief. Advocate Batoi, at number 1, we're talking about withdrawal.
Mhm.
And at number 8, we're talking about stopping of a prosecution. And in our case here, we are concentrating on withdrawal,
That is correct, Chairperson.
no stopping of prosecution.
That is correct.
Thank you.
Proceed, Advocate Mutlamunyana.
Thank you, Madam Chair. I will leave it at that. If the witness disagrees with me, I don't want to proceed where a witness disagrees with me.
Please,
And
counsel. You cannot be seen to, or heard on the record to be saying that. I think you must withdraw that because it's going to go into the record.
I withdraw, Madam Chair.
Thank you.
With respect, I withdraw, and that concludes her evidence.
Please.
Chairperson, well, we didn't get to the end of my affidavit,
I
so.
beg your pardon.
Chairperson, we
What did
didn't,
you say, counsel? Were you saying it concludes her evidence?
Yes, I said it concludes her evidence.
Yes,
Course.
thank you, Advocate Batoi. Advocate Mutlamunyane suggests to us that this is the end of your evidence.
Because what remains, Madam Chair, has already been dealt with.
Is there anything else that, without repeating, that you'd like to place before us that you think is of relevance for our determination?
Thank you, Chairperson. I think the evidence leader is correct. Much of it has already been placed before this inquiry. Perhaps just to mention paragraph 191, the last two paragraphs of my affidavit. After my referral of the matter to the President via the Minister, a further legal opinion was obtained from the Minister of Justice. My understanding is that I stand to be corrected. My understanding is that this was an opinion that was obtained on the suggestion or on the request of the President's office. And through the Minister of Justice, that opinion was obtained from Advocate KD Moroka, SC. It's dated 18 March 2024. It's in the legal bundle, the opinions referenced there. And Advocate Moroka, SC, also concluded that there was sufficient evidence of wrongdoing on the part of Advocate Chauke in respect of both the Boyson matter and the Bluli matter to warrant an inquiry into his fitness to hold office. Thank you, Chairperson. That concludes the sequence of events.
Yes, thank you. And the opinion is in the bundles of opinions. We have seen that.
LO, that's correct, Chairperson.
I suppose that it will be properly marked as an exhibit
It will,
together
Madam.
with others.
It will, Madam Chair. I can only point out that it is contained in LO4 bundle, and the pages are reflected in paragraph 191, LO 001064 to LO 001094.
Thank you, Councillor. Is that all, Madam?
Yes, thank you, Chairperson.
Yes, thank you. Advocate Motlamunyane, we had agreed that at the end of Advocate Batoi's testimony, you will hand up a list of exhibits. That document must be read in to be handed up.
Ready, Madam. Madam Chair, I'm informed that the document is ready, but it needs to be updated to include those documents that were referred to today.
Well, in that event, it means that you will hand these documents, copies to us, to our researchers, extra copies for the Secretariat. And it seems to us that then you will have to postpone the cross-examination to tomorrow, 9 o'clock.
Yes, indeed. Madam Chair, we also have noted that we don't have the 2012 indictment, signed indictment. We only have the 2015 signed indictment. So if they could also furnish us with that.
Did you bring that to their attention before?
Yes, we assumed that the indictment was there, but it turns out to be a draft indictment. But we haven't pertinently raised the absence of the indictment with them.
Advocate Motlamunyane, would you have the indictment that Advocate Kaitobi is referring to?
I'll ask that it be acquired and be handed to them.
But I suppose, Advocate Kaitobi, you will nonetheless be ready to start 9 o'clock tomorrow.
Yes. We're not trying
In
to
the
try to postpone.
meantime, thank you, sir. If your team can provide that document, I remember also outstanding, if my correction is correct, a bundle of the dockets, the 28 dockets that were referred to earlier, At the initial stage of this proceedings, Advocate Andrew Chauke, do you refer to that? Do you have those dockets?
Yes, they've given them to us, Madam Chair. There was one outstanding, which was the KwaZulu. They've also given that to us. The problem is that we don't have the judgment acquitting Mr. Padeache, who was the accused.
Well, some of these matters need not be discussed amongst yourself through us. Lawyers must speak to one another and make sure that you get those documents. If there is a resistance to provide, then you can approach us. But I suppose the team knows precisely what they need to do. And we are, Advocate Batoy, minded to adjourn now. We will have that document that is outstanding and probably even the copies of the dockets. I also want to look at them. We've been talking about 28 dockets.
I believe it's quite voluminous. I think it's 23, but quite voluminous.
Whatever it is, our task is to try to find the truth and to gather evidential material to be able to recommend. So whatever it is, please make it available to us, because much has been said about it in these records. It will be oblivious of us not to consider that if it is necessary. Well, all counsel, please, you can maybe refer to your notes and then remember all other documents that you said were outstanding. We cannot pinpoint to all of them, but to my recollection, the dockets and that document that is in the pipeline, we will receive it tomorrow, and we will adjourn until 9 o'clock tomorrow morning. Yes, thank you. Thank you, Advocate Batoy. We will adjourn.